Welcome back to the room, and welcome to those of you who just joined us. Today it's a pretty packed day. For those of you who just joined us, I'm Francesca Mingrone with the Center for International Environmental Law. We're here today to celebrate and participate in an historical moment. This is the first day of the oral hearings before the International Court of Justice in the process that will lead to an advisory opinion on what states' obligations are with regard to climate change. The courts will be hearing from many states. More than 90 have decided to attend, which is definitely an unprecedented level of participation. 98 states, to be precise, and 12 international organizations. This morning, we heard the first of those states. We heard from Vanuatu and the group of spearheaded countries, South Africa, Albania, and Germany. And from 3 p.m. On, we will have another group of countries, which really represents a wide range of perspectives. We will have Antigua and Barbuda, Saudi Arabia, Australia, Bahamas, Bangladesh, and Barbados. And I think this will really give us a sense of the most contentious issues, main points for alignment. And today, at this roundtable, which I'm very happy to moderate, we will start unpacking some of these big legal and political questions. Some of them have been raised already this morning, and others will come up as the advisory opinion process unfolds. I'm very happy to introduce to you the panel of our experts. We have here with me Benjamin Schachter with the Office of the High Commissioner for Human Rights. Professor Ginevra Lemoli, legal counsel for the African Union, but also professor at the European Institute University, but here in her capacity as professor of international law. Yves Lador from Air Justice, UN representative. And then we have joining online, and I hope they are online already, Sebastian Doik with the Center for International Environmental Law, and Jule Shankberger with the World Youth for Climate Justice. Are there other panelists? I heard that maybe David Boyd, the former Special Rapporteur on the Environment, would join, but we don't know whether he's actually available. We will find out as we go. So we really want this to be quite an interactive space. So I'll ask for some opening remarks by our experts, and then I would really encourage also people in the room to ask questions. We heard many points that have been raised by the states. Big questions around what's the relationship between different bodies of law, especially this tension between the human rights framework and Paris Agreement, UNFCCC as pure climate change law. The question of extraterritorial obligations. Should states be held accountable for harms that occur outside of their jurisdiction? Question of common but differentiated responsibilities and national capabilities in understanding what the obligations are. The content of these obligations, whether it's mitigation, adaptation, international cooperation, and also what rights specifically are affected. We heard arguments around, for instance, whether the right to life is affected or not by climate change. What's the status of the right to healthy environment? Questions around self-determination, and Vanuatu made some important compelling cases around that. And also the centrality of science. How does science inform the state's obligations with regard to climate change in understanding the obligations, but also the consequences? And of course, looking at the consequences, what happens once a responsibility is established, once harm occurs. And this is one of the key questions that the court will be asked also to talk on. And finally, cross-cutting issues, the role of fossil fuels, for instance. What kind of measures should be deemed acceptable for states to take to address climate change? Something I haven't heard addressed this morning is the question of corporate accountability. I would expect that this is a dimension that some other states will raise, and I'd be keen also for our experts to address that. Maybe I will start with Sebastian, who's joining us together with Jule straight from The Hague. They're there in the core of the action. And so, Seb, over to you just to have a sense of what's the temperature there. definitely this morning gave us a good sense of different arguments and positions. And so having your take being on the ground would be a great way to start this conversation.
Absolutely, and thank you for being with us in Geneva, for following the proceedings remotely. That's really one of the critical benefits also of this process, is to finally be able to... I see you might have some issues with the sound.
No,
Can you give me a thumbs up? No, all good? Perfect. One of the benefits of this process is to actually enable the members of the public or civil society to actually track what are the legal arguments that states put forward when they are required to actually develop their thinking in relation to the scope of legal obligations in the context of climate change. So it's the more screenings we can have, like the one taking place in Geneva, the better, to make sure that states understand that this is a process also to bring accountability with regards to the legal arguments put forward. And in this context, I think we heard some unfortunate arguments this morning, relatively frustrating, that do not necessarily represent what we had expected from some of the states, including because of the work that they do in Geneva. So something I look forward to unpacking. This morning we had, yesterday actually, we had a lot of energy in Den Haag because we had an opening plenary that was organized by the Pacific Youth, that brought a lot of testimonies, but also different forms of expression from the Pacific to rebrand or like reframe the process in the context of the demands, the lived experiences of Pacific Islanders in a way that doesn't resonate as strongly in the court because of a very carefully prepared choreography there in the court. And in the court itself, you might have seen from some of the shots during the webcast, there are not so many people in the building itself. A lot of states will be coming on a rotation basis, but we know that some of the main hotels here in Den Haag are packed with delegations. We've already seen delegates walking through, or legal counsels walking through the streets of Den Haag, even if they are going to present their legal arguments in more than a week, at the end of week two, for instance, for the Swiss delegation. So it is quite interesting to see so much convergence in terms of legal minds, but also the fact that this process is going to really put governments not in a negotiation position for some of the delegations. I guess it will be to what they experience at the climate COP, for instance, but really in a place where the strength of the argument is going to be assessed on the basis of the validity of the legal arguments and not on the on the type of nations they represent. And that is going to be something that will probably be quite different from what we've seen at the UN climate conferences, and hopefully also will deliver a different outcome afterwards. And just conclude by highlighting the fact that this morning there was a rally in front of the court. The main message was, we are watching young people from the Pacific, but also globally rallying and making their presence known. And so I just really want to conclude by acknowledging the fact that this process would have been unthinkable 10 years ago, and it was made possible by through the leadership of Pacific Island states, but in particular also the youth from the Pacific and beyond who really drove this initiative forward. So really looking forward to the discussion now.
Thank you very much for this for sharing what's the temperature like, and definitely we heard from also the Vanuatu's ambassador here in Geneva this morning, and we're very glad to have Yule on the panel because it's crucial to acknowledge really the leadership that small island nations and the youth have played throughout the process, not just in bringing it to reality and convincing the international community that an advisory opinion was necessary, but also to make sure that then there was a high level of scrutiny and participation. And I would imagine that the exceptionally high number of states that have decided to engage in the process is also a reflection of that. I would now turn to Professor Lemoli. One of the core battleground, if I may, is really this tension between what's the body of law that should be applied when we talk about states' obligations with regard to climate change. We've heard arguments, and I would expect that the other countries will come in even in a more stronger way about the primacy of the Paris Agreement and the UNFCCC, the Climate Convention, as the main body of law that applies when we do discuss obligations of states with regard to climate change, and then just being informed by human rights, while there other arguments we heard, specifically by Vanuatu and Albania, were made very strong arguments in that sense, that actually all bodies of law that that are relevant to climate change do apply, and specifically human rights law. So that should be the main, together with the climate regime, the main body that is applicable. So can you help us understand a bit the tension, what the implications are of one or the other approach, and how you see it from your technical perspective?
Thank you. First, also let me thank Ciel for the invitation to this very timely event.
I'm sorry, I have an issue with the microphone because I cannot hear you.
Can you hear me now? Okay, excellent. Great. So I followed this morning all the statements, oral statements, with much interest, and also I found some of these speeches extremely inspiring. But what I was most interested in was to really try to unpack the legal elements and whether delegations have given weight to some of them or not, or have been silent. And so one of the first elements was the role of science, inevitably, and as well as the conduct at stake. Then, namely, the acts and omissions that cause significant harm to the environment, a conduct that is defined, well defined in the resolution of the General Assembly. Second, the applicable law and the legal obligations, which in turn also provide the basis for assessing whether the relevant conduct is consistent or inconsistent with international law, and subsequently also assess possible legal consequences arising from the breach of international law. So with regard to the positions that states have maintained this morning, they were quite aligned with also they were aligned with what they included in their written statements, and so there were no surprises from their perspective, even though I hoped that some of them may have changed their opinion, but that was not the case. Second, also, we could find definitely an alignment between the position of Vanuatu and the MSG and the position of Albania, and on the other side, the position maintained by South Africa and Germany. Let me explain. So as regards the legal conduct, both pretty much all four argued that even though some implicitly that the relevant conduct implies the anthropogenic greenhouse gas emissions that cause harm to the environment. And the role of science has also played a relevant role. Some of them made quotes, cited IPCC reports directly. Some others instead simply made reference to the fact that there is scientific consensus, which is already an important element. Especially considering that also last week the court has met with some of the IPCC scientific experts that also drafted some of these reports. So there is also this element that is quite new. I believe this is the first time that for advisory proceedings, the ICJ also triggers and implements the relevant articles of the statute in order to consult scientific experts. Then the second element related to the applicable law and the obligations. We've seen both Vanuatu and Albania arguing that the whole corpus of international law applies. This has important implications. Vanuatu decided to focus on the obligations arising from the right to self-determination and the duty of due diligence. which both implies the duty to prevent and protect the environment from significant harm, and also the duty to protect the marine environment. Also making reference to cases of the ICJ, which is something that reassures the court. So it's important to refer to not only advisory opinions, previous advisory opinions, but also other cases. And in this case, the pulp mills case has been mentioned both by Vanuatu as well as by Germany. Now, in addition, also, Albania made other references to customary law as well as to human rights law. It made reference, for instance, to gender rights, which I believe that were quite relevant for the pleadings, and also taking examples from other written statements. So try not only to make a statement based on the problematics of the state, but really taking a global approach also in the pleading. Then lastly, as regards instead the breach, both argued that this conduct is in breach of international law. Even Professor Vinuales concluded with a sentence saying that if transboundary pollution is unlawful, how can we argue that the worst pollution, case of pollution, the ultimate form of pollution, to correct myself, is not unlawful, and also cited Lemkin and making a comparison with the genocide. So, which is quite an effective point also that helps understanding what is at stake. Then, in conclusion, also Vanuatu unpacked the different legal consequences that we can find also under the ILC Articles of State Responsibility between Article 30 and Article 36. And these are cessation of the unlawful act and also the reparation in terms of both restitution and compensation. And also added satisfaction, which is also quite important, as also the Council, Margareta Veverinck explained, it means providing also a spiritual, to use the terms, spiritual dignitary aspects. Then in terms of, and also added that the duty related to the peremptory nature of the right to self-determination implies the obligation to recognize continuous sovereignty of states and the duty to cooperate. So instead, on the other side, we have the presentations and the statements provided by South Africa and Germany that and in line exactly with what also they argued in their written statements, their position has been that only the climate change regime applies. And according, in the words of the agent for South Africa, this is most appropriate for the court, according to the agent. It is the most directly relevant applicable law, and I'm quoting. And also, the agent said that these obligations are nuanced, so here we see that by also narrowing down the scope of the obligations relevant under for climate change and for acts and omissions that cause significant harm to the environment, what we are excluding are and we are setting aside is the possibility of triggering and of opening the discourse on legal consequences. Why? Because the climate change regime, as it has been also explained by the Council of Germany, does not provide a system for liability or compensation. So it is instead it sets a compliance mechanism that inevitably does not bite, let's put it in this way. So Germany argued that Germany is committed to implementing financial channels, such as and made reference to the Green Climate Fund. These are all relevant. So these are all relevant solutions. On the other side, again, as I mentioned before, removing from the tools, other instruments and international law, what we do not have are first the applicability of the articles on state responsibility first, and then of course obligation arising from primary sources, because the ILC articles on state responsibility set are so-called secondary rules, because they set rules related to state responsibility, related to possible breach of primary rules that are found instead in treaties, in conventions, in binding instruments. So also to conclude on this point, the agent that pleaded for Germany, Professor Zimmermann, argued that climate change regime and human rights law are parallel treaty regimes, but they also do not act in isolation, and however concluded that the climate change regime is the only one that sets relevant obligations in this case. I personally also, in my position as a professor, I disagree with this point. The argument that has been put forward has been the one that there are certain cases of the Human Rights Committee that have never recognized that human rights are violated in the event of climate change. On one side, that is true. On the other side, for example, in Te Tota versus New Zealand, there were issues of evidences. So there were cases, related elements that did play a role and inevitably precluded the committee to conclude that there was an immediate risk in that case to argue that there was a violation of human rights. And plus, we have the decision of the European Court of Human Rights, the Klimatsynjorinen, and other decisions also at the domestic level that have recognized that human rights are impacted by climate change. So human rights law does apply in the context of climate change, and also the Human Rights Committee has recognized this in its general comment on right to life in paragraphs 26 and 62, where the link has been made. So these are my first impressions. I don't want to take too much, but thank you for your attention.
Thank you so much. I think that's a great way to put a framework also to better understand where the points of tensions are. And another element where I also found diverging views is to what extent states have obligations vis-a-vis future generations. There's this tension of what's the scope of obligations, especially in the context of human rights law. The core human rights instruments do not explicitly mention future generations, but there is a wealth of jurisprudence and work by treaty bodies that actually does include future generations in obligations of states. And on that, I would be keen to hear from you, Le. The youth have been actively engaged in the process, of course, highlighting the impacts that climate change is having on current young generations, but also on future ones. And since you're also there in The Hague, it would be great to also get your perspective on what's the situation like there. I don't think you might have access to the room today, but we know that the youth are really mobilizing, as Seb was saying earlier, a wide number of civil society, activists, scholars. So really scrutiny is high, also thanks to your own action over there. So over to you, Yule, and thanks once again for joining us in this very busy day.
Yeah, thank you so much for the invitation. And I hope connection holds up, but otherwise do let me know. Yeah, big thank you for the invitation and the recognition, of course, of the youth and civil society efforts that have led us to this point. I'm sure you've mentioned it, but of course it came from Pacific Youth and was carried by civil society and young people from around the world to this very day. So it's very, very special to stand with some of the key youth who were instrumental in taking it forward with the Vanuatu government and with some of the key civil society members who are very important in the Pacific, but also in other parts of the world this morning in front of the court. And maybe Seb shared that as well. We kicked off the day with a solidarity demonstration in front of the court, which was really, really powerful. And despite very cold temperatures and a drizzle, the elements were against us, but yeah, it's a really powerful moment. And I think we had always dreamed, and we always jokingly said that we hope that inside the court you would be able to hear the chants of the people outside. And I did actually get access to inside the Great Hall of Justice, and one of the, I think, 5 or so people that they let in, which is by a lottery system. So yeah, I don't have special access. So you can sign up and try to and hope to be lucky. And when we had after we had done security and we were walking up to the courthouse, you could actually hear the chants, and so I felt really reassured that what we had set out to do, the demonstration really paid off and did exactly that. That you would hear the people's voices inside. I think it's so interesting to hear other people's reflections, and we've now been on break for a little over an hour, so we've chatted amongst friends a little with about what we've heard. We of course were not allowed to speak in the court, so we and we couldn't bring any devices, so we just had to try to remember absolutely everything that was said. So still unpacking what was said there. I think the submissions by Vanuatu, of course, and MSG in the morning with Cynthia closing it as a youth representative were extremely powerful, and we were tearing up on the public gallery and watching it. It was so clear. I think how we it was ended right before Cynthia with Margareta speaking about reparations and tying it to climate finance, and I was very surprised, of course, because I don't have access to the submissions, but how specific they were on phasing out fossil fuels and not granting new permissions, and the financial reparations piece. I think very optimistic by that, and then all our positive energy were squashed by Germany's submissions. I'd say that from an activist perspective, and I can't see, of course, everyone else is in the room, so I know I have to be potentially careful, but I'd say that we were very surprised by what we heard, how they spoke about the right to a healthy environment and the rights of future generations and intergenerational equity. And if you sit on the public gallery, you can actually see all the judges and all the lawyers, all the people sitting, the state delegates, and you could see in their faces that people were surprised by how they had come out and how they had spoken. So definitely it wasn't just us, it was people wondering what they had said. I think it aligns broadly with what we heard at COP, but yeah, still disheartening to see. And yeah, I'm very sorry that I am from Germany. I am very sorry what was said there today, and surprising. And I'm very interested to see how we can unpack that. I think all states, with those who've spoken this morning, drew a connection with COP. And so I think it's very clear that these two spaces are interacting, and it would be interesting to see how we can draw some more attention to these really bad creative legal arguments that were put forward this morning, and that we might see in the afternoon the next days as well. So an invitation to continue engaging. I'm really eager to learn from the other people on the panel. Thanks a lot. But overall, I think the spirits here are high, and yeah, very grateful for all the people up this morning, and will continue to do so in the next 2 weeks. Thanks a lot.
Thank you very much, Yule, for your perspective, and also for Seb's sharing of what's the situation on the ground. I think he really adds a human element in this very complex and technical processes that seem so far away. But hearing that maybe the judges could hear the chants in the room, I think adds definitely a more familiar and human face to the whole process. We've heard from you, from Professor Lemoli, about the question of reparation as one of the legal consequences if breach occurs. And so turning to Ben from the Office of the High Commissioner for Human Rights, the office recently released a report. I believe it's the first ever report by the office really looking at human rights obligations in the context of loss and damage and really making the case that states do have a human rights obligation to provide redress and reparations in the context of climate change. And that's definitely is and is going to be at the core of some of the arguments about the consequences, and something that the court hopefully will be confronted with in their own reasoning. So I'd be keen to hear from your perspective what your thoughts, also based on what we heard this morning, and some of the going more in depth about the question of reparations once harm occurs.
Thank you very much. I was told to be loud, so apologies if I'm too loud. So first of all, thank you to the organizers for the invitation. I think we've all been eagerly anticipating these hearings, and now we've got a solid couple of weeks to hear diverse legal arguments. I'm not going to speak towards those specifically, but rather towards the body of work that's been done by the Office of the High Commissioner for Human Rights and the human rights mechanisms that we support. And that body of work began many, many years ago. It includes more than 20 reports drafted by the Office of the High Commissioner for Human Rights for either the High Commissioner or the Secretary General. The report that Francesca referenced on loss and damage is one of the most recent ones, and it is a report of the Secretary General. And I will speak to that in a moment. I also want to highlight that in addition to the work OHCHR has done, the special procedures mechanisms of the Human Rights Council and the human rights treaty bodies that OHCHR supports have extensively addressed human rights and climate change in their work. And across this very large body of work, it has been made very clear that states do have human rights obligations with respect to climate change. And we have made recommendations and findings with respect to the scope and content of those obligations. It's certainly interesting and exciting to hear some of that work being discussed in the context of the ICJ advisory opinion. All of those reports and the resolutions of the Human Rights Council were submitted by the UN Office of Legal Affairs as part of the dossier that the International Court of Justice has to consider. So you can find all of the reports up to whatever that cutoff date was last year, and the more recent reports on our website. And I encourage you to consider those. The work on loss and damage specifically is a study that was submitted pursuant to Human Rights Council Resolution 53/6. And that resolution requested the Secretary General to prepare a study on the impact of loss and damage from the adverse effect of climate change on the full enjoyment of human rights, exploring equity-based approaches and solutions to addressing the same. The report that was prepared is informed by a wide range of inputs and contributions from across human rights bodies, the UN system, states, and civil society organizations. And it starts by outlining legal and policy frameworks for addressing the impact of loss and damage on human rights. It finds that the right to an effective remedy is a fundamental principle of international human rights law, and remedies should be available and accessible to all people for human rights violations resulting from loss and damage. This is required by human rights law and includes as appropriate the right to reparation including restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. Remedies can serve to address not only past harm, but they can also play a preventative role in terms of mitigation and adaptation to avert and minimize loss and damage. We also have found that the obligations of states in the context of climate change extend to all rights holders and to harms that occur both inside and beyond boundaries. That the historical emissions source attribution is critical to the overall attribution of responsibilities for climate impact, and clearly stated that those responsible for climate change are accountable for compensatory measures, including financial, for harm incurred. There is both a moral rationale and a legal basis for holding fossil fuel companies accountable for climate harms and reparations as well. The study outlines 5 pathways for human rights and equity-based approaches to addressing loss and damage. These are anchoring relevant policies and measures in human rights, building climate resilience through social security and a just transition towards a human rights economy, promoting human rights and equity-based approaches to mobilize financing and free fiscal space, advancing access to judicial remedy, and developing climate justice and transitional justice approaches. So here, we have the opportunity to hopefully learn a lot more in the coming year about how the International Court of Justice, the Inter-American Court of Human Rights, and other judicial mechanisms interpret the law in the context of climate change. And from the perspective of OHCHR and this particular report, we encourage you all to read and consider the way that the office and the human rights mechanisms it supports have gone about articulating human rights obligations in the context of climate change. Thank you.
Thank you very much. And indeed, the work that the office is conducting is essential to inform these processes, states thinking, really cross-pollinate different processes and bodies of law. And on this same direction, I would turn to Yves Lador. You've been working in Geneva for many years now. You're one of the environmental pillars in the Genève International. And we've been working since 2008 to really ensure that climate was part of the work of the Human Rights Council specifically, but also work in the context of human rights treaty bodies. And it was quite empowering and uplifting to hear how many times countries did reference already this morning the work by treaty bodies, the Council special procedures. So keen to hear some thought on that, really on how key Geneva is in informing these processes, and how can we incorporate whatever comes out of the advisory opinion back to Geneva.
Yeah, thank you very much, Francesca. And indeed, I mean, it was quite striking this morning to hear how clear there were some references to the work done here in Geneva. It seemed actually to be even central to a lot of the discussion. When we started this morning with the opening remarks, with the small discussion before it starts, we were wondering, what is going to happen, and basically making a list of hopes or shopping list in a way. And now it started. Of course, it's much too early to jump to any conclusions. We still need to hear so many states, and then, of course, what will be important is the final opinion that the court will produce. But clearly, it was amazing to see all these references to Human Rights Council resolution, how it was central to so many of the arguments, to some of the reports of the special rapporteurs. And I was also surprised that they were mentioned more than once by more than one country. And of course, that was less of a surprise, but it was great to hear it so clearly, some of the general comments or decisions from the treaty bodies. This, of course, brings us back to some of the discussion we've had in this room and in the rooms around, where for so long we heard, the two things are totally separate, they're disconnected, don't mix them. It's still an argument we hear today, and I think one of the first things we can already see at the end of this morning is this argument is dead. Now, of course, it doesn't mean that there is an agreement on how you do the articulation, but it is clear that it is articulated, and I think even the diverging opinions we've heard this morning, we're all agreeing at least on that point, that there is an argument between the different legal regimes. So it is clear now from that the discussion here in Geneva are going to be informed by the outcome of the ICJ. We see very well that the work which is happening here in these rooms and in these corridors are not just siloed and isolated. They are really part of a more global system, and we can, for once, see so clearly how this is articulated. There's also another element I'd like to underline, but it was said by Sebastian Duick a few minutes ago, is the question in this process about the transparency, because here everybody can hear the arguments of their own country. And we already just heard that there are some surprises. Some people saying, what? This is what my country is arguing about? We're going to have many of other type of surprises, fortunately or unfortunately, during the coming days. But this is also very important because here, for example, in this room, again, a number of resolutions are being discussed. And of course, and that's normal, that's the way it has to be, the arguments is not exchanged. So you don't always afterwards see what is the exact arguments that countries are coming into a negotiation with. And then, of course, it's much more difficult to report back because they didn't say this, and they can even pretend to their own national organization, no, that's not our position, once the decision comes out. And so you don't have always a very clear transparency. Here, we can hear them, we can hear what they are saying, and this will probably, again, also inform the discussion we have here. So, few thoughts about some of the possible consequences of what can come up and what probably we're going to have to work here in Geneva as what we could already see some kind of a follow-up. First, on the question of coherence. Of course, it's much too early to say how we will see this coherence come out of the advisory opinion. But one thing which was really striking is first the argument we heard more than once this morning that this is the general, this is a body that has general capacity to look at the whole of the international law. And that was striking to see that others are really doing cherry picking. That they pick up, for example, you take some regional decisions from courts, but you only take those from the European Court. You don't even mention that you had very interesting and actually diverging positions from, let's say, the Inter-American Court. So, and not only that, you could see a lot of cherry picking. We're used to see that, but here it was really obvious. So, of course, we can hope that the opinion coming out of the ICJ will provide some kind of a more coherent approach, and that we will build on that, and some of this cherry picking will stop. Important also the importance of the role of science. Probably we're going to, because we saw that it's very well argued. Again, we hope that it will be also strong in the advisory opinion. They have heard also scientific bodies before these the current hearings. So we hope that we will be able here also in Geneva afterwards in the work we do in the Human Rights Council to articulate with stronger arguments, with more strength, the articulation between science and the impact that people have to suffer from climate change and the whole process. Another element which will be also very important is the issue of remedies. We clearly saw this morning how there is a kind of a game. Okay, we're going to look more finance through the lenses of climate change because that's volunteer. And we forgot that actually we do have already long-term obligations since quite a long time coming from the obligation we have ratified under the covenants and all of the human rights instruments. So we could see this kind of a game, and I hope also here that the advisory opinion will provide some guidance to try to stop this game, which is extremely damageable for victims. And perhaps a very last point. Rightly so, Francesca, you said at the beginning that there was not much said about companies' accountability, but there was one point I'd like to underline because it was very quickly mentioned and we should not miss it. There was a reference to the question of investor-states dispute settlement. This is an extremely important issue. And what is very interesting is part of the discussion we have on this at the level of the Human Rights Council, but now also in other circles, is derived from the report that was produced by the Special Rapporteur, David Boyd, when he was Special Rapporteur on Human Rights and the Environment, on these mechanisms. And this has really drawn attention from a number of countries and other bodies about the impact. There was a lot of criticism about it because of the amounts and so on, so it's huge. But there was not always a very clear understanding of what does it means for environmental protection, for the work in the field of climate change, and just for sovereignty, or for the capacity of people to defend their own rights. And so it was very important to have this argument that was presented here. Here again, I think this is an interesting element to be followed in the work we will be doing here in the Human Rights Council. Thank you very much.
Thank you very much for learning these dimensions and indeed for making more evident what the point that was made on ISDS. It was an argument, I think, made by Albania a bit in passing, but hopefully will be unpacked more because indeed is a huge barrier to effective action on climate change. Also a huge financial strain for those countries that then want to take meaningful action to protect the environment and human rights. I would perhaps, conscious of time, open the floor for questions from the public. We're here also to allow the diplomatic and civil society community to engage, so happy to take a few questions. I would ask you to introduce yourself with name and organization or state of affiliation before asking. So I see a lady over there, please.
Alev Mine of the One Goal Initiative for Governance. A probably simple question, the differences between duty, responsibility, obligation, and accountability in terms of, I guess, legal outcomes. And what Mr. Schachter meant about by human rights economy, is there a framework for that? Or climate justice through social security that kind of excludes the private sector? And lastly, by which channels is the court informed about our discussion here? Thank you.
Thank you very much. Happy to take another question if there is. Otherwise, I will turn to our experts. Then perhaps Professor, oh, sorry. Yes, please, go ahead.
Hello. I would have a question. I think it would be mostly for Professor Lemoli and for Yula. Regarding the mention of future generations in the pleadings. Because with the current state of the, I didn't introduce myself, I'm sorry. I'll do that at the end. Regarding the current state of the principle of intergenerational equity and also the patchwork of various groups of terms used to denote the obligation towards future generations. We saw the pleadings of Germany today, and we will likely see in the coming days the invocation of these obligations to support opposite sides of what should the opinion be. Where do we go from here regarding what do the obligations towards future generations say about our state's conduct vis-a-vis climate change? It's off. Wait, that one? I think, okay, that works. I'm sorry. Yeah, so I think that was my entire question, and I omitted the introduction. So I'm Joachim Strelski. I'm a master's student in Geneva Graduate Institute in International Law.
Another question, and then turn to the experts, please.
Openshaw. I work for ICJR. Thank you so much to the organisers of this. So I had two very quick questions. One relates to the question of causal links. So different representatives or different speakers for the different parties spoke differently about whether that could be established. And I'm just interested in your thoughts to this point of what has been put forward. And the second question is actually about the court itself. Do you have any insights as to the membership of the court, what different members might, where they might lean? Is there any reading of their past decisions that gives us any hint? I know it's really early days, but I'd be interested to hear that. Thanks so much.
Thank you very much. We have a very broad range of questions. One about what do we mean by duties, obligations, and so on. So that's definitely something I would imagine it's important to address, and perhaps I would turn to you. We had a question on the human rights economy. Perhaps, Ben, you want to address it. On future generations, I would be keen to hear from Sébastien and Yule. On casual links, I don't know who would be comfortable. Maybe also you can touch upon it. And then on the court, I don't know, perhaps those of you who are in The Hague can give us a sense of whether we can have a sense of where some judges stand. But perhaps over to you, Professor, and then we can hear from the others.
Thank you. Can you hear me? Okay, great. Thank you. So, so starting with the first question on duty, obligations, and accountability. Just also to make it simple. When we talk about a duty and obligation, we refer to a binding obligation and a binding duty arising from a primary source of international law, for example, a treaty or a convention. So to make an example, the right to life, Article 6 of the ICCPR. And instead, the moment that we talk about accountability, this means triggering the system of the secondary source of international law that are, and namely those defined under the ILC Articles of State Responsibility, which require to have first a breach of an international legal obligation, and second, obligation arising from a primary source, so in the example that I made before, the right to life, and second, an attribution. So the breach must be attributable to the state. So, for instance, the state of Republic of Vanuatu in the written statements and also today made and unpacked the element of attribution in order to address the possible attribution of the conduct to both the single states, plurality of states. Otherwise, also in principle, the act could be a breach of international law. And this also, the element of attribution brings me to the last question on the causal link. Because according also to this cluster of norms under the ILC Articles of State Responsibility, according to Article 15, we can define the acts and omissions causing significant harm to the environment over time as an aggregate, as a composite act. And this is what has been argued by many states that have in this way also overcome the problem of the causal link. They argued that acts and omission that can be divided in, can be explained in two ways. One, positive conducts of promoting activities that facilitate the fossil fuels and the inaction of not cutting down the emissions, or the inaction of not doing much at the national level to also to, for instance, consider accountable business enterprises that also play a role. So these acts and omission can be considered as an aggregate and therefore contributing over time to the harm to the environment. Then on the question instead on children, on future generations' rights, how do we frame that? I acted as a counsel in the legal team of the African Union. The legal counsel is Ajer Gweldic, and she will be the one pleading with Professor Makambengwe on Friday for the African Union. And the element of intergenerational equity as well as of future generation has been key in all the different discussions as also we had at the level of the international organization, the African Union, but also in the different workshops that we had with the different countries in Africa that wanted also to coordinate with the African Union to bring one voice to the court. And the way we framed it, and as from what I've been able also to see in other written statements, the main approach has been to consider the Convention on Children's Rights as the one that is the source of obligations to protect, ensure, and respect, protect, and ensure human rights of children and of future generations. And in addition, let me add that there are also some regional instruments that play a role, and that the African Charter also makes reference to future generations. And so this is why it can be, it depends also in some pleadings, we may also see arguments based on regional instruments that will be also quite important to enrich the legal arguments and the debate more generally. Thank you.
Thank you. Perhaps on these notes, yes, Yves, and then let's see from The Hague if Seb and Yule want to add something. But go ahead, Yves.
Well, I was not going to talk about the future generation arguments, but I just wanted to add a point on what has been said about the causal link, because it was mentioned also this morning, is that it's an argument which is, I mean, still kept very strong by the United States, but actually through science less and less relevant, because now with the progress of what we call attribution science, we see more and more on especially extreme events, how much you can attribute it to climate change. So the arguments, oh, we don't know, is less and less relevant. And then we also have two elements. We see the contribution that states are providing to the global warming currently and historically. So it is actually possible to have a rather interesting and pretty well-defined attribution on how much you contribute to this element. And of course, what was said before, and we also have now the issue in the field of the health sector, where more and more, even at the domestic level, you see courts saying, yes, even if we can't immediately say this act had an impact directly on this person, we see that globally, for example, in the terms of health, a number of companies have done wrongdoing, and they have now to contribute to remedies which are given to the people. So the argument, I think, is really decreasing, but also we understand why you have such a strong resistance on that. Sorry, I just wanted to add this on that. Thank you very much.
Thank you. I cannot see Sebastian or Yule, but happy, yes. I see you, Yule. Go ahead.
Thanks. Seb is, of course, the experts on future generations, right? So I'll just take the easier question on what we think the judge, how the court's informed of what's going on outside. What we've heard is that they do get on a regular basis.
Yule, I'm sorry. Can you put your mic closer to your mouth, because we cannot? Yes, hear you very well.
Sorry.
Thanks.
Let me try again. I said, sorry, I'll pick the question on the court. I think that's, and then defer to Seb on the future generations question. What we've heard is that I believe it's on a daily basis that judges get newspaper clippings and reports of what's going on outside. So they know what is going on. They had to drive into the court through the streets where we were protesting, and we had put up banners, some which have come from COP. And of course, they live in the city. And this case, because it's been going on for so long, we've of course there were quite a few events where their staff has been invited to, the legal teams and people working at the court, so they have heard about the narrative and some of the key arguments before today as well. So I think there are even of course they are yeah, kind of not maybe here today to have this conversation with us, I think they're still a part of kind of an ecosystem and the context. They're very well aware of the attention and the pressure that is on them. They have yeah, we have done of course internally a bit of a mapping of the judges, and what I think overall the sense is that this is a very good time and the bench is likely to find I'm going to say in favor of us, or to find something progressive. I think it's still very interesting for me this morning to watch how they're listening, and some extremely attentive, and especially one judge very much not attentive and yawning into the delegates' faces, which seemed very very odd and rude to me. So of course we can still yeah, we can still see some surprises, but overall I think right now is a good time. That's what we've heard, and they are aware that there is conversations and civil society actions happening around it. So I'm carefully optimistic.
Thank you so much, Yule. Is Seb still online? Then I would give him the floor.
Yeah, I'm here.
Thank you. Perfect.
Yeah, just I'm conscious of time, so extremely briefly, I heard the question about the human rights of future generation and how it had already come under quite strong pushback from the German legal council. I must say, like, we've heard so many references to actually Geneva-based human rights mechanisms and institutions, but I hope other delegations will also pick up on the writings of special rapporteurs of UN human rights treaty bodies in relation to the human rights of future generation. And there is much to draw from, whether it's from the special rapporteur on the right to development, the Committee on the Rights of a Child, or other sources of law, the Committee on Economic, Social and Cultural Rights as well, that is finalizing a general comment touching on the human rights of future generation. One comment from my part, I mentioned it, I alluded to this in my earlier comment, is the fact that I think main surprise of the morning is how Germany came across with a commitment expressed to human rights, but then really deconstructing the relevance of human rights obligation towards future generation, extraterritorial obligations, and the right to a healthy environment, and also citing the work of the Human Rights Committee in relation to Article 6, right to life, in a manner that I think surprised a lot of legal experts. Technically speaking, the words were probably correct, but the spirit of the work of the Human Rights Committee is definitely to point to the fact that climate change can be found as threatening the right to life, and states can breach their obligation under Article 6 if they fail to act on climate change. I think there is no question of this, and the way the German government has raised this morning some of his argument, I think undermines a little bit the credibility of some of the attacks against the scope of his legal obligation. And so I really hope it will motivate other delegations to really make sure that as they come this afternoon or in the coming days, they will re-engage on those arguments and actually provide sufficient legal arguments for the court to really embrace a wider range of sources as well, because some of the cases that were selected in relation to, for instance, deconstructing the extraterritorial nature of human rights obligation was extremely selective and very unfortunate. So look forward to seeing the responses from other delegation in that context.
Thank you very much. Seb, I'm conscious of time. We see that the hearings are resuming. Maybe just over to Ben for a final answer on the human rights economy, and then we can wrap up.
Yeah, thank you. And I'll be quick and may not be able to do full justice to that work that the office is doing to articulate a human rights economy. First thing I would say, and just want to be very clear about, is that the UN Guiding Principles on Business and Human Rights do emphasize the responsibilities of businesses, and they apply in the context of harms or abuses related to the human right to a clean, healthy, and sustainable environment, which, as we all know, has been globally recognized through UN General Assembly Resolution 76/300. The human rights economy is one that is guided by human rights, including the right to a healthy environment, and has the objective of advancing human rights. Human rights and rule of law, therefore, become part of the fiduciary duty of businesses, as they should be and were always meant to be. And human rights due diligence includes an environmental dimension. I also briefly referenced Social Security and just transition and climate justice and transitional justice. All of these are elements of the Secretary General's report on loss and damage. And one of the reasons for this is that we were asked to consider equity-based and human rights-based approaches to loss and damage. And the challenge, there is whatever the ICJ advisory opinion says, it's advisory. Judicial recourse is critical in this, discussion of loss and damage, but it's also very time-consuming and it's not accessible to all people everywhere. So when we're talking about something that involves a multitude of perpetrators, being climate change, a sort of collective of perpetrators, and a multitude of people suffering human rights harms, we need to think about ways to ensure that those most affected have access to remedy. Transitional justice offers some potential lessons for how to address complex situations like this, as do avenues related to fulfilling human rights obligations, existing human rights obligations, including with respect to Social Security and with respect to the transition to a sustainable economies and societies that is needed and been agreed to. Thank you.
Thank you very much for the questions. Once again to our experts. I'm very sorry that we have to wrap up already this roundtable, but we will have other moments for reflection, specifically on the 12th from 6:30 to 8:30 p.m. at the Geneva Academy. We will have a moment to really unpack what we will have heard, and by then we will have heard most of the states. The hearings are now resuming. Antigua and Barbuda is now speaking. Will be followed by Saudi Arabia, Australia. There will be then a quick break at 4:30, and then back with Bahamas, Bangladesh, and Barbados. We will have some very quick concluding remarks at 6 p.m. Just wanted to bring to your attention that there is an event going on in parallel to this, actually starting in 20 minutes in room 17, organized also by the Geneva Environment Network and UNDP, on how can citizens drive systems change and catalyze climate action. There will be some refreshments, so if you are in need of coffee, you're more than welcome to step out of the room and enjoy their own beverages, since we are partnering with the Geneva Environment Network. That's called the cooperation. Thank you very much. I really appreciate the level of engagement throughout this very long day. Thanks to our panelists in person, and thanks to Sébastien Yule over there. Best of luck with the continuation of the hearings. Thank you.
What must small states, or states generally, do under international law to protect the climate system for present and future generations? What is the responsibility of those whose actions have contributed disproportionately to this crisis? Antigua and Barbuda stands in solidarity with other vulnerable nations, particularly our fellow small island states. Together, we endure the worst of a crisis that we did not create. But today, we also stand with the millions across the globe who are looking to this court for a path forward, for clarity, justice, and certainly hope. We believe in the power of international law to bring about change. This court's voice can inspire the urgent action that has eluded the political arena. It can remind the world that the rights of small nations, of vulnerable peoples, and of future generations are not secondary, but fundamental. The people of Antigua and Barbuda are counting on you. The world is counting on you. And I say here that this is not just a legal question. It is a matter of survival. Mr. President, I ask that you now call on Mr. Phillips, who will address the legal points. Thank you.
Gaston Brownie, I now give the floor to Mr. Phillips. You have the floor, sir.
Mr. President, members of the court, in order to assist the court, Antigua and Barbuda will address a select number of points. I begin with the Paris Agreement. The scale of the climate crisis was known as long ago as Antigua and Barbuda will address a select number of points. I begin with the Paris Agreement. The scale of the climate crisis was known as long ago as the 1960s. In a collective effort to combat climate change, states agreed on the climate treaties, most recently the Paris Agreement in 2015. Today, however, many high-emitting states attempt to rely on the climate treaties as a shield to escape accountability. Their approach to the Paris Agreement would deprive the most vulnerable of any redress. First, these states argue, in effect, that the obligations of the Paris Agreement are merely procedural. In other words, so long as a state ticks the box to identify a nationally determined contribution, or NDC, it has complied with Article 4 of the agreement. For these states, this is so even if both the ambition and the implementation of the NDC fall manifestly short of a meaningful contribution to ensuring that temperatures do not rise above 1.5 degrees. Second, certain of these states simultaneously argue that either the Paris Agreement displaces all other relevant rules of international law, including the customary obligation of prevention, or that compliance with Paris translates automatically to compliance with those other rules. These two arguments together would lead to a surprising conclusion that the climate change treaties leave the world and the most vulnerable states therein less well protected than if these treaties had never been concluded. This is a dangerously regressive approach. It is also erroneous for the following reasons. First, NDCs are not empty decorations. Under Article 4, each state must set its proposed contribution to a level corresponding to a fair share of remaining carbon budget to meet the 1.5 degree temperature goal. And they must take all measures at their disposal to achieve their proposed contribution. This understanding is further corroborated by a COP decision obliging parties to explain in writing how their NDC is both fair and ambitious in light of national circumstances, and how it contributes to the Paris temperature goal. Second, the customary obligation of prevention remains in any event applicable along with other treaty-related obligations. As the chamber of the ICJ recognized in the Elsie case, the court must not accept that an important principle of customary international law should be held to have been tacitly dispensed with in the absence of any words making a clear intention to do so. There is no evidence that the states in the climate treaties themselves or in their contemporaneous or subsequent practice intended to dispense with the existing legal protections. To the contrary, the UNFCCC confirms the continued relevance of both custom and treaty-based regimes. The climate treaties and other sources of law mutually reinforce and shed light on one another. Compliance with the Paris Agreement is necessary, but may not be sufficient for compliance with states' obligations under custom, UNCLOS, and human rights institutions. Antigua and Barbuda therefore agrees with the dozens of other participants in these proceedings, and the European Court of Human Rights and the ICJ that Paris Agreement does not displace and instead operates harmoniously with the customary obligation of prevention and other relevant rules of international law. I turn now to the obligation of prevention. The attempt by a handful of participants to render this customary rule inapplicable is unconvincing. First, high-emitting states consistently attempt to distinguish between conventional transboundary harm, to which the obligation of prevention applies, and harm occasioned by the climate crisis, to which allegedly it does not. This contrived distinction has no basis in law or in fact. The large-scale nature of the transboundary environmental crisis does not carry it beyond the scope of international law. To the contrary, the protections of international law apply with added rigor. Second, some states attempt to argue that applying the obligation of prevention to climate change would require the emergence of new customary rules. This is wrong as a matter of law. It confuses the existence of a norm with its application to a given set of facts. There is no doubt that the general obligation to prevent significant transboundary harm exists in custom. International courts and tribunals can and must apply that norm when presented with specific facts. States have not excluded the application of existing customary norm to the climate change. To the contrary, climate treaties explicitly affirm the ongoing applicability of customary obligations. As to the content of the obligation, because high-emitting states have not acted and are not acting with the appropriate diligence in light of the nature of the risk and their capabilities and responsibilities, I will touch briefly on these elements. The severity of the risk cannot be overstated. With each successive IPCC report, our understanding of the magnitude of the risk has increased. We also know with scientific precision that the remaining carbon budget available to keep global warming under 1.5 degrees and the harms that will occur failing that. There is, in the IPCC's words, a rapidly closing window of opportunity to avoid catastrophic damage. The standard of diligence applicable to high-emitting states in this context is, in the words of ITLOS, stringent. Allocating a greater burden of emission reductions to high-emitting developed states is inherent in the notion of due diligence obligation. The court has already accepted that the level of required diligence is premised on each state's capabilities. In the context of climate change, the level of required diligence is also differentiated based on each state's responsibilities. And this flows from the principle of CBDR-RC. The argument of certain high-emitting states that CBDR-RC has no role outside the climate treaties is plainly wrong. The UNFCCC requires its parties to be guided by the principle of CBDR-RC in their actions, both to achieve the Convention's objectives as well as to implement the provisions of the Convention. As a result, when states take action to achieve climate objectives, they must respect the principle of CBDR-RC, including when they are acting under the prevention obligation and human rights obligations. The European Court of Human Rights recently confirmed this interpretation. Seeking a harmonious interpretation across legal regimes, the European Court relied on the principle of CBDR-RC outside the climate treaties, specifically in the context of states' due diligence. States' due diligence obligations to mitigate greenhouse gas emissions from their international human rights obligations. Taking these elements together, the obligations of states are clear. To act with diligence, states must make rapid, deep, and sustained cuts to national greenhouse gas emissions in light of the remaining carbon budget. They must do so taking into account the evolving level of risk and their respective capabilities and responsibilities. The IPCC, which produces the best available science, also stressed the importance of carbon budgets. and identified the remaining budgets for keeping within the 1.5-degree limit, as each state must use not more than an equitable share thereof, with developed states taking the lead. It necessarily follows that, firstly, a developed state must do its utmost, using all means at its disposal, to reduce its emissions considerably more than 43% by 2030, 60% by 2035, 69% by 2040, and 84% by 2080, compared with 2019 levels. To achieve a net zero CO2 emissions well before 2050 and net zero greenhouse gas emissions well before early 2070. Second, a developing country must still contribute, but its equitable share may be less demanding depending on the past and present emissions and the level of development and capabilities. Some states emphasize that there is yet no internationally agreed equitable share of the carbon budget, but we say this is not an excuse. The absence of an agreed methodology for apportioning shares simply means that there is a corresponding obligation to cooperate to reach that agreement. In the absence of an agreement, a diligent state must develop its own methodology to determine its equitable share using the best available science in good faith recognition of its own capabilities and responsibilities. Moving to the second question, state responsibility. All participants accept two principles. First, a breach of international obligation automatically gives rise to state responsibility. And second, the content of that responsibility, namely the state's duty to make reparation, depends on the existence of harm and a causal nexus between the breach and the harm. The application of the second principle in the case of climate change, however, is where some participants differ. While the harm caused by climate change is well established, some participants argue that the necessary causal link cannot be proved. They contend that the causal complexity makes it impossible for an obligation to make reparation to arise in respect of a wrongful emission. In other words, they ask the court to sanction a situation of breach with no responsibility to make reparation for it. That would be, in the language of the Trail Smelter Award, a perversion of fundamental principles of justice, to deny all relief to the injured person and thereby relieve the wrongdoer from making any amend from his acts. When the court has been faced with similar arguments, it has consistently rejected them. It has first reaffirmed that even though the state of science regarding the causal link between the wrongful act and the damage may be uncertain, that will not automatically preclude the existence of a duty to make reparation. Second, it has identified principles to accommodate uncertainties in assessing the existence, extent, and cause of harm. The court should affirm this approach in this present case. It is useful to examine how causation is accommodated in the rules governing existence, content, and extent of state responsibility. As a first step, determining the existence of an internationally wrongful act requires that conduct constitutes a breach of an international obligation which is attributable to the state. For the obligation of prevention, a state must have failed to use all means at its disposal to prevent emissions emanating from within its territory or subject to its jurisdiction from resulting in significant harm to the environment. The court has confirmed that causation does not play a key role in determining a breach of this type of obligation. States are under a duty to act, which is not dependent on the certainty that the action taken will succeed in preventing the relevant harm, or even has a likelihood of doing so. On this basis, both the ITLOS and the European Court of Human Rights have rejected the so-called drop-in-the-ocean argument that no state can have breached due diligence obligations in the context of climate change because no single state's emissions reductions measures could make a meaningful difference in this crisis. The second step is to identify the content of state responsibility. There will be a duty to make reparation where there is first, injury, and second, a causal relationship between the wrongful act and the injury. Both conditions are capable of being fulfilled in the context of climate change. First, the existence of the injury is axiomatic. In these proceedings alone, scores of states will describe the injury that they have and continue to be suffering. For some small island states, injury rises to the level of compromising their continued existence. Second, the causal link between the wrongful conduct and harm is capable of being satisfied in individual cases. This is because it is scientifically possible to determine a state's contribution to global warming, and because principles exist to address remaining areas of causal uncertainty. This includes the flexibility of the applicable causal standard. The court has affirmed that causation must be sufficiently direct and certain, with sufficiently being a relative concept that takes into account the particular circumstances. Indeed, in the armed activities case, the court confirmed that the causal nexus required may vary depending on the primary rule violated and the nature and extent of the injury. The court should confirm that approach in this present case. As an illustration of this flexible standard, in armed activities, the court adopted a presumption of causation. It held that it was for the breaching state to establish that a particular injury was not caused by its failure to act within the diligence to prevent certain conduct of individuals within its territorial control. The same presumption applies by analogy in respect of wrongful emissions from a state's territory that are clearly contributing to the climate change harm. This would be complementary to the scientific proof of causal connections between specific states' emissions and harm, and could be one way to address remaining causal uncertainties. A number of participants argue to the contrary, that it is not scientifically possible to satisfy the causal link between a state's wrongful emissions and harms sustained so that a duty to make reparation would arise. These states are wrong, but they are also asking the court to find, as I have already noted, that states may be responsible for breaches of international law, but that there will be no obligation to make reparation. This would prejudge or even prevent the commencement of future cases. To ask the court to go to such lengths is remarkable. What these states are primarily concerned about is being held responsible for more than their fair share in a situation where there are concurrent causes of harm. But that concerns the extent of the duty to make reparations, not whether that duty exists at all. As the court has held, the fact that damage was the result of a concurrent causes is not sufficient to exempt a responsible state from any obligation to make reparations. The third step concerns the extent of responsibility. International law has mechanisms that deal with apportionment of the duty to make reparations across multiple states. The armed activities case, again, is instructive. The court confirmed that in certain cases where multiple causes result in an injury, responsibility for part of such injury should instead be allocated among those actors or causes. These principles, supported by scientific techniques, allow the court to best approximate the relevant state's share of responsibility in light of contributing factors. In sum, causal complexity in the context of climate change is no bar to the existence, content, or extent of state responsibility, including a duty to make reparations. Antigua and Barbuda respectfully urges the court to give particular credence to the views of small island developing states, especially affected states, on the applicability of the duty to make reparations in the context of the climate change crisis. Mr. President, members of the court, Antigua and Barbuda thanks you for your time.
I thank the representatives of Antigua and Barbuda for their presentation. I now invite the next participating delegation, Saudi Arabia, to address the court, and I call upon His Highness Prince Jalawi Turki Al Saud to take the floor.
Bismillah ar-Rahman ar-Rahim. Mr. President, members of the court, it's a great honor to appear before you in these important proceedings and to do so on behalf of the Kingdom of Saudi Arabia. As a country particularly vulnerable to extreme heat, weather scarcity, desertification, and other adverse effects of climate change, the Kingdom acknowledges the urgency of taking action to mitigate the harmful effects of climate change. As a state with a resource-dependent economy, economic diversification objectives, and historically low greenhouse gas emissions, the Kingdom emphasizes the importance of international cooperation to advance global efforts to protect the climate system by addressing anthropogenic greenhouse gas emissions. At the same time, efforts to address greenhouse gas emissions must occur alongside efforts to ensure the fulfillment of the objectives such as energy security, energy affordability, poverty eradication, food security, and economic development, among other goals, in order to achieve sustainable development. Peoples around the world have historically had unequal access to energy and have made unequal contributions to atmospheric greenhouse gas concentrations. Those states that participated in the Industrial Revolution early on enjoyed advantages in welfare, infrastructure, and economic development. Having regard to state differentiated responsibilities and capacities requires recognition of different starting points, development needs, and social context. The response will not be uniform across countries and regions. The Specialized Treaty Regime on Climate Change complies of the United Nations Framework Convention on Climate Change, the Kyoto Protocol, and the Paris Agreement address these complexities. Under the Specialized Treaty Regime, the Kingdom actively participated in negotiations and contributes to the response of climate change. The Kingdom's response includes nationally determined contribution, as well as several ambitious initiatives, such as the Saudi Green Initiative and the Middle East Green Initiative. Additional details on the Kingdom's efforts and initiatives are in our written statement. Mr. President, allow me to highlight 3 important points. First, the Specialized Treaty Regime on Climate Change provides a complete answer to the question on obligation and consequences. Second, the Specialized Treaty Regime on Climate Change is a remarkable achievement. It is specifically designed to address the complex global phenomenon on climate change. It was reached through determined and rigorous negotiations and guided by the multilaterally agreed principles. The treaty regime reflects the good faith efforts of all participating states to reach pragmatic and effective agreement on what are immensely complex policy matters for every state. Third, to impose any obligations or consequences that go beyond or conflict with those contained in the Specialized Treaty Regime on Climate Change would risk undermining the integrity of this regime and impaired future progress in international efforts to protect the climate system. Mr. President, our next speaker will be Sir Michael Wood, who will address you on the role of the court and the applied law. He will be followed by Ms. Ghaida Bajaba from the Saudi Ministry of Energy, who will speak to the application of the 2 questions put by the General Assembly. Mr. President, members of the court, I thank you for your attention. I request that you invite Sir Michael Wood to the podium.
I thank His Highness Prince Jalawi Turki Al Saud. I now give the floor to Sir Michael Wood.
Mr. President, members of the court, it's an honor to appear before you and to do so on behalf of the Kingdom of Saudi Arabia. In the time available, I must be selective. We maintain and attach importance to all the points in our written statement and written comments. The fact that we do not cover certain points made by others does not mean that the Kingdom agrees with all that they say. Mr. President, I shall address the Court's role in these proceedings, as well as the applicable law. We urge the Court to adopt a cautious approach when answering the two questions posed by the General Assembly. The need for caution was addressed in the General Assembly debate upon the adoption of Resolution 77-276, when many states emphasized that it was not for the Court to impose additional obligations or responsibilities on states. The consensus among states at the General Assembly was based on a clear understanding of the role of the Court and the scope of the questions. Mr. President, members of the Court's role in advisory proceedings, as in all of its work, is to apply the lex lata. This is particularly so given ongoing negotiations among states pursuant to the specialized treaty regime on climate change to further advance global efforts to protect the climate system by addressing anthropogenic greenhouse gas emissions, negotiations which are based on state sovereignty and on consent. Despite some calls that seem to be urging the Court to impose new obligations, advisory proceedings cannot be a substitute for negotiation. An effective and progressive response to the threat of climate change requires active and good faith negotiation and cooperation among states based on states' own policy choices and on their consent. Such choices are not matters that courts can impose from above. The specialized treaty regime on climate change contains a well-established framework that governs states' negotiation and cooperation, providing the Court with the basis for addressing the questions before it. This regime establishes a legitimate mechanism for stabilizing greenhouse gas concentrations in the atmosphere, precisely because it is based on the clear consent of states. A judicial response that departs from the lex lata and alters the specialized treaty regime on climate change would undermine the credibility and effectiveness of the existing legal regime and the framework for negotiation, cooperation, and consent that the treaties establish. Mr. President, members of the Court, the chapeau added by the General Assembly to the questions in Resolution 77-276 lists a series of instruments, duties, rights, and principles, some applicable, some not. In any event, it is not for the General Assembly to determine what law is applicable to answering the questions put to the Court. The chapeau cannot have an effect on the Court's function of determining the applicable law. In the recent occupied Palestinian territory opinion, after setting out a rather similar chapeau, the Court went on to make clear that, and I quote, "The Court will determine which rules of international law are relevant for answering the questions posed by the General Assembly," end quote. Jura novit curia. It is for the Court to determine the applicable law. I now turn to the applicable law that is relevant to the questions put by the General Assembly. All participants accept that, under international law, states' climate change obligations are primarily governed by the specialized treaty regime on climate change. It is fundamental that the Court reaffirms the primacy of this specialized treaty regime, since it reflects the consensus of states on how to address the global threat of climate change. Some, however, seem to be suggesting that it is the scientists that determine states' legal obligations. That is not so. It is the treaties, not scientists, that set out legal obligations. One other important point that I should make is the coherence of the specialized treaty regime. Contrary to certain suggestions, the Kyoto Protocol, the Paris Agreement, and other instruments and measures developed exclusively under the UNFCCC enhance the implementation of the UNFCCC and build upon the principles and provisions established in the UNFCCC. Mr. President, members of the Court, that concludes my short statement, and I request that you now invite Ms. Ghaida Bajba to the podium. I thank you, Mr. President.
I thank Sir Michael Wood. I now give the floor to Ms. Ghaida Bajba. Madam, you have the floor.
Mr. President, members of the Court, my name is Ghaida Bajba from the Ministry of Energy. It's a great honor to address you and to do so on behalf of the Kingdom of Saudi Arabia. In response to question A, I shall first address certain aspects of the specialized treaty regime on climate change. The importance of nationally determined contributions, NDCs, certain fundamental principles of the treaty regime and its primacy. I shall then say a word about the interpretation of the specialized treaty regime, which cannot be expanded by reference to other instruments. And finally, I should offer some thoughts on question B. Mr. President, members of the Court, the Kingdom and other participants have described in detail in their written pleadings the specialized treaty regime on climate change. Among other things, all states have a binding obligations to prepare, communicate, and maintain their NDCs, taking into account common but differentiated responsibilities and respective capabilities and national circumstances. While the NDC process is mandatory, the content, implementation, and achievement of the NDCs themselves are not legally binding. States have full discretion to determine their NDCs. That is intentional. That deliberate choice for voluntary contributions by states is central to a proper understanding of states' obligations, referred to in the questions before the Court. NDCs concern an obligation of best efforts, not of result. The specialized treaty regime on climate change is based upon certain fundamental principles. I only have time to mention two and refer you to the Kingdom's written pleadings for further details. First, the principle of common but differentiated responsibilities and respective capabilities. As is universally recognized, the atmospheric concentrations of greenhouse gases contributing to climate change date back to emissions from the Industrial Revolution. This historic responsibility is recognized in the treaty regime. Second, the treaty regime emphasizes stabilizing atmospheric greenhouse gas concentration in a time frame that expressly enables economic development to proceed in a sustainable manner and on the basis of equity and in the context of sustainable development efforts to eradicate poverty. These principles are the bedrock of the treaty regime, essential for many states to be able to join the negotiating consensus. It is important that they are clearly affirmed in the Court's opinion. The Kingdom believes there is no room to play down the primacy of the specialized treaty regime on climate change and overlook the crucial importance of the worldwide acceptance of the regime. The Paris Agreement's requirement for the parties to identify and maintain indices is a carefully designed mechanism for advancing progress towards the Paris goals. Almost every state has submitted an NDC. This is a significant achievement. The specialized treaty regime on climate change provides no basis for the court to recommend limits on fossil fuel extraction and production. No basis whatsoever. The specialized treaty regime requires parties to consider actions necessary to meet the specific needs and concerns of states not listed in Annex 1 to the UNFCCC and affected by response measure to climate change, including those with economies highly dependent on fossil fuel production and export. Failure to respect these provisions would undermine the carefully negotiated balance under the specialized treaty regime that accommodates the diverse economic circumstances of all parties. Perhaps most critically, the court should not interrupt the treaties in a way that goes beyond what was agreed by the negotiating states. This is particularly so with respect to aspirational provisions, such as the temperature goals in Article 2 of Paris Agreement, which do not impose legally binding obligations. Some participants argue that scientists should determine states' obligation. That, with respect, cannot be the case. As stated previously, it is the treaties that set the obligations. Nothing would threaten future progress in international effort to protect the climate system more than distorting and misrepresenting agreed language. Apart from the specialized treaty regime, none of the treaties or instruments mentioned in the chapeau to the questions was intended to address climate change. These instruments were not designed to address the unique challenges presented by the climate change. This is the case in the Law of the Sea Convention, which has been considered by states in the context of the advisory proceedings in Hamburg. We set out at some length our considered positions on ATLAS advisory opinion in our written comments. In short, the law of the sea cannot be interpreted as imposing obligations that are inconsistent with or go beyond those agreed in the specialized treaty regime. Mr. President, members of the court, the principle of international environmental law and international human rights law referenced in the chapeau were not developed in the context of climate change or agreed by states in the specialized treaty regime. They are not applicable to the questions before the court. Nor can the application of notions such as harmonization or systematic integration serve as basis for imposing wholly new or inconsistent obligations on states with respect to climate change. The no-harm principle was not designed to apply to the protection of the climate system from greenhouse gas emissions, nor does it do so. It concerns transboundary environmental damage caused directly by activities in the territory of one state to the territory of a neighboring state. As several participants have observed in their written pleadings, the no-harm principle applies in a bilateral context where there is a clear link between the source of harm and the affected state. The principle doesn't apply, whereas here, anthropogenic climate change results from a whole range of varied and diffuse activities and events that emit greenhouse gases accumulating over a long period of time. Some participants have referred to a right to a safe, clean, healthy, and sustainable environment. that as we and others have explained, such a right hasn't entered the corpus of international law, and the implications flowing from any such right haven't been spelled out and agreed. The obligations under human rights treaties also do not address the protection of the climate system from anthropogenic greenhouse gas emissions. It is important to note that international human rights obligations apply only to the states parties to the particular treaty, and then only in respect to individuals in their territory or under their jurisdiction. The statements of human rights bodies and special rapporteur do not affect this position. As the court recalled in the Qatar versus United Arab Emirates case in connection with the Human Rights Convention, and I quote, "The interpretation must be based above all on the text of the treaty." End of the quote. Decisions of regional or domestic courts and tribunals are not source of general international law. There are many reasons for this, primarily, of course, because national or regional courts are usually applying national or regional law, including domestic constitutional law or regional human rights law. Even when they seek to apply public international law, they may do so through a domestic or regional lens. Mr. President, members of the court, I now turn to question B. Like question A, question B doesn't ask the court to seek to qualify the activities that resulted in emissions. It was clear when the questions were asked that there were no intention for the court to consider the responsibility or liability of individual states. As we and others have explained in our written pleadings, the climate change treaty regime contains its own compliance mechanism to deal with the legal consequences where a significant harm is caused. In addition to mitigation and adaptation requirements, the treaty regime contains a loss and damage mechanism which seeks to deal with cases of harm. Mr. President, members of the court, as you are aware, a loss and damage fund has already been established. Where a party considers that another party has breached its obligation, it may invoke the relevant compliance and dispute settlement mechanisms, including under Article 15 of the Paris Agreement. This provision establishes a mechanism to facilitate implementation of and promote compliance with the Paris Agreement. Some argue for application of the residual rules of customary international law on state responsibility, as proposed by International Law Commission. However, as many participants have recognized in their written pleadings, there are significant problems with applying these residual rules in the present context. Above all, there are highly problematic questions of causation. In any event, Article 55 of the Articles on State Responsibility provides that they do not apply where and to the extent that the conditions for the existence of an internationally wrongful act or the content or implementation of the international responsibility of a state are governed by special rules of international law. The specialized treaty regime on climate change itself determines the legal consequences of significant harm to the climate system. Finally, with respect to point 2 in question B, the specialized treaty regime doesn't, The specialized treaty The specialized treaty regime doesn't confer rights upon individuals. Moreover, as others have also made clear, the concept of peoples and individuals of future generations is too indeterminate for them to have legal status or standing, or for claims to be made on their behalf. Mr. President, I would like to conclude with 3 points. First, the Kingdom of Saudi Arabia respectfully requests the Court to answer questions A and B by confirming that state obligations to protect the climate system and other parts of the environment from anthropogenic greenhouse gas emissions are those set out in the specialized treaty regime on climate change. And the legal consequences under the obligations are to be determined by reference to the specialized treaty regime on climate change. Second, determining obligations that are inconsistent with or go beyond those agreed in the specialized treaty regime would undermine the ongoing and future progress in international efforts to protect the climate system. Third, to strengthen the global response to the threat of climate change, the Kingdom is committed to the full implementation of the principles and obligations embodied in the specialized treaty regime, UNFCCC, the Kyoto Protocol, and Paris Agreement. Mr. President, members of the Court, that concludes the oral presentation of the Kingdom of Saudi Arabia. We thank you for your attention. I thank you, Mr. President.
I thank the representatives of Saudi Arabia for their presentation. I now give the delegation of Australia to invite the delegation of Australia to address the Court, and I give the floor to Mr. Jesse Clark.
Mr. President, Madam Vice President, distinguished members of the Court, it is a great honour to appear before you on behalf of Australia. Climate change is one of the defining challenges of our time. Australia is resolutely committed to taking urgent action to address the effects of anthropogenic greenhouse gas emissions on the climate system. In that context, Australia was proud to co-sponsor the United Nations General Assembly resolution requesting an advisory opinion from this Court. Climate change is the greatest shared threat to all countries. It is having significant impacts, in particular on small island states, and these impacts will only increase as the temperature of the planet rises. Indeed, climate change poses the single greatest threat to the livelihoods, security, and well-being of the peoples of small island states, including Pacific island states. Australia commends the long-standing leadership of our Pacific neighbours in shaping global responses to climate change, and, in particular, Vanuatu's leadership in driving forward the request for this advisory opinion, together with the core group. Australia is committed to working with the Pacific to strengthen the global responses to climate change. Global cooperation is critical to delivering an effective response to climate change. Australia acknowledges the extent of the challenge posed by climate change and recognises that ambitious individual and collective action must be undertaken urgently. In this regard, the UNFCCC and the Paris Agreement are the central instruments that provide the framework for international cooperation and commitments to tackle the grave challenge of climate change. Collective action under these treaties has resulted in a reduction over time of projected future levels of greenhouse gas emissions. However, parties are not yet on track to ensure the objective of the UNFCCC and the goals of the Paris Agreement are met. Australia recognises there is an urgent need for states to take stronger individual action now to achieve our collective goals, which is even more pronounced today than it was in 1992. Unless greenhouse gas emissions peak and rapidly reduce in the near term, we will experience rapid warming and more pronounced changes to sea levels, river flow, water temperature, and precipitation. To maximize the chance of meeting the temperature goals of the Paris Agreement, the world's largest emitters, which have not yet peaked and begun to reduce their emissions, must rapidly do so. Australia is taking urgent and ambitious climate action to reduce greenhouse gas emissions, decarbonise its economy, strengthen national and regional adaptation, and increase resilience to the impacts of climate change. Australia is resolutely committed to achieving the objective of the UNFCCC and the goals of the Paris Agreement, including by strengthening its emissions reduction targets, legislating a commitment to achieve net zero by 2050, and delivering on its climate finance commitments. The questions before you provide an important opportunity for the Court to clarify the existing legal obligations of all states and the particular legal consequences for all states with respect to climate change. The Court has not been asked to opine on the international responsibility of or consequences for any specific state or group of states. In particular, question B does not require or invite the Court to determine whether breaches of any such obligations have occurred or will occur, nor whether particular states are specially affected or injured. Australia observes that there are many areas of consensus among the participants to these proceedings. In particular, there is broad agreement on the competence of the Court to render an advisory opinion in this matter, the central role played by the UNFCCC and the Paris Agreement in setting out states' obligations to address climate change, and the need to address the complex challenges of climate change on the basis of best available science, as most recently reflected in the 6th report of the Intergovernmental Panel on Climate Change. Australia was also pleased to see strong consensus on the need for international cooperation and increased ambition in collective responses to climate change. By way of outline, the Solicitor General of Australia will address the UNFCCC and the Paris Agreement, and the relevance of customary international law and the United Nations Convention on the Law of the Sea. Dr. Parlett will address you on question B as regards legal consequences. I thank the Court and, Mr. President, request that you now pass the floor to the Solicitor General.
I thank Mr. Clark. I now give the floor to Mr. Stephen Donaghy. Sir, you have the floor.
Mr. President, Madam Vice President, distinguished members of the Court, it's a great honour to appear before you again on behalf of Australia. There is broad consensus amongst the participants in these proceedings on the central role of the UNFCCC and the Paris Agreement to the questions before the Court. The preambular language to both treaties describes climate change as a common concern of humankind, and consistently with that statement, these two treaties have near universal participation. They are the primary source of states' obligation under international law in respect of climate change, setting out both collective goals and aims alongside individual obligations and commitments. They create the central cooperative framework for the collective action that is needed to address both the causes and the impacts of climate change. The first global stocktake under the Paris Agreement showed that parties have made significant progress but are not currently on track to achieve the goals of the Paris Agreement. Importantly, however, the Paris Agreement has built-in mechanisms to address this, because each party must set an NDC every 5 years, which represents a progression beyond its last NDC, is informed by the outcome of the global stocktake, and which reflects the states' highest possible ambition. The global stocktake sets out clear next steps to address the gaps in climate ambition and implementation, including first, encouraging parties to set ambitious next NDCs that are economy-wide, cover all gases and sectors, and are aligned with limiting global warming to 1.5 degrees as informed by the latest science. And second, setting new collective energy efforts to triple renewable energy capacity and double the annual rate of energy efficiency improvements by 2030, and to transition away from fossil fuels in our energy systems. The outcomes of the global stocktake demonstrate the dynamic process the climate change treaty regime creates for assessing progress and for adjusting action over time. The differentiated obligations of parties to the UNFCCC and the Paris Agreements, and the capacity of those obligations to adjust in light of parties' evolving national circumstances, and as best available science continues to inform the steps required to respond to climate change, underlies their status as the primary source of relevant legal obligations. Australia recognises that other treaties contain obligations that are relevant to the protection of the climate system, or that play an important complementary role alongside the climate change treaties. These include UNCLOS, international environmental treaties, sector-specific agreements that address specific types of anthropogenic greenhouse gas emissions, and international human rights treaties. Australia also recognises that the duty to cooperate under customary international environmental law is applicable to states' actions to address climate change. In respect of the relationship between the climate change treaties and other areas of law, Australia makes two observations. First, contrary to the submissions of some participants, it is not necessary for the court to have regard to the rule of lex specialis, which is primarily focused on the resolution of normative conflicts in relation to the complementary obligations that exist under international law for the protection of the climate system. Second, this court should promote a harmonious interpretation of states' obligations to protect the climate system from greenhouse gas emissions. As such, where other treaties and customary international law also impose obligations relevant to the protection of the climate system from climate change, those obligations must be interpreted consistently with those that have been carefully negotiated and agreed by the vast majority of states under the UNFCCC and the Paris Agreement. In this context, Australia emphasises that the rule reflected in Article 31(3)(c) of the Vienna Convention on the Law of Treaties addresses a situation where rules of international law external to a treaty are relevant to its interpretation, but does not operate to incorporate obligations from one treaty or from customary international law into another treaty. I turn next to the relevance of customary international law. The vast majority of participants, including Australia, recognise that the principle of prevention is a rule of customary international law that applies to significant transboundary harm. There is, however, divergence in relation to whether this principle applies to environmental harm caused by anthropogenic greenhouse gas emissions. Some participants suggest that the principle of prevention is of general application and therefore applies to harm caused by greenhouse gas emissions. Australia respectfully submits that the principle of prevention does not apply to harm of that kind for two reasons. The first reason is that greenhouse gas emissions are materially different from the conventional case of transboundary harm. Yet it is only in the context of those conventional cases that the court has applied the principle of prevention. Those conventional cases involve a direct and temporally proximate cause of environmental harm from an identifiable source spreading from one state to a neighbouring state, such as discharge of pollution into a river or discharges of noxious gases near the border between states. That was the context in pulp mills, where the court held that a state is obliged to use all the means at its disposal in order to avoid activities which take place in its territory or any area under its jurisdiction, causing significant harm to the environment of another state. More recently, the court again applied the principle of prevention to claims of significant harm to the environment of an adjacent state in construction of a road. In Australia's submission, the unique nature of the mechanism by which greenhouse gas emissions cause harm to the environment provides an important point of distinction from cases of ordinary transboundary harm. Specifically, harm from greenhouse gas emissions arises by reason of the cumulative build-up of greenhouse gases in the atmosphere over a long period of time, being emissions which many different states and countless private actors are responsible. Furthermore, the harm that results is widespread rather than localised and may be experienced in places far removed from the source of emissions that contributed to its occurrence, rather than simply in neighbouring states. That combination of circumstances means that greenhouse gas emissions give rise to novel challenge in applying the requirements of causation of significant harm and in the determination of responsibility for specific impacts. The second reason that the principle of prevention does not apply to harm caused by greenhouse gas emissions is that there is no consistent or widespread state practice or opinio juris to confirm the existence and content of obligations deriving from the principle of prevention in that context. The divergence in views is clear from the views expressed by states participating in this very proceeding. This point is confirmed by the fact that when the international community addressed the obligations of states concerning greenhouse gas emissions through the UNFCCC and the Paris Agreement, it did not incorporate either the substantive or the procedural obligations that the court has found to be derived from the principle of prevention in conventional cases of transboundary harm. Instead, it developed more tailored and adjustable mechanisms to address the greater complexity of greenhouse gas emissions. For these reasons, to extend the principle of prevention to greenhouse gas emissions would not account for the unique features of the global challenge that such emissions pose. Such an extension would also be unsupported by the requisite state practice and opinio juris. Given the widespread adoption of the specialised climate change treaties, customary international law should not be held to have developed in a way that imposes obligations with a different content. If, contrary to our primary submission, the court concludes that the substantive aspect of the principle of prevention does apply to greenhouse gas emissions, compliance would be assessed against a standard of due diligence. That being so, Australia's view, which it shares with several participants in this proceeding, is that the UNFCCC and the Paris Agreement specify what that standard requires for states party to those treaties. Equally, compliance with those treaties will also satisfy the procedural aspect of the principle, such as obligations regarding cooperation and information sharing. As the very purpose of the UNFCCC and the Paris Agreement is to embody the agreements of states as to the measures that are appropriate and necessary to address greenhouse gas emissions and their environmental impacts, compliance with those agreed measures entails compliance with any customary international law obligations arising from the principle of prevention. Finally, I turn to UNCLOS. The vast majority of participants, including Australia, recognise the relevance of obligations arising under UNCLOS for the protection of the climate system. There is broad consensus that Part 12 of UNCLOS applies to pollution of the marine environment by anthropogenic greenhouse gas emissions, with the consequence that such emissions may enliven a number of obligations under that part. As a framework agreement, UNCLOS, in many instances, leaves the development of specific rules and standards to competent international organisations and specific sectoral agreements. In the context of climate change, those standards and rules are found in the UNFCCC and the Paris Agreement, to which the vast majority of states that are party to UNCLOS are also party. In those circumstances, Australia submits that Part 12 of UNCLOS should not be interpreted as imposing obligations with respect to greenhouse gas emissions that are inconsistent with or that go beyond the obligations agreed in the specific climate change treaties. Otherwise, the agreements of states to very general obligations in Part 12 of UNCLOS would cut across the more specific agreements of those same states as to how they should individually and collectively address the harm caused to the whole environment, including the marine environment, by greenhouse gas emissions. Australia welcomes the recent ITLOS advisory opinion and the contribution it has made to clarifying the obligations of states to protect and preserve the marine environment from the impacts of climate change. Australia fully participated in those proceedings, and it recognises and respects the important role of small island states, including Pacific Island states, in requesting and obtaining that opinion. Australia wishes to highlight 5 key observations of ITLOS, which are consistent with the views of a number of participants in this proceeding and with the submissions that I have just made concerning UNCLOS. First, that greenhouse gas emissions constitute pollution of the marine environment within the meaning of Article 114 of UNCLOS. Second, that as the primary legal instruments addressing the global problem of climate change, the UNFCCC and the Paris Agreement are relevant to the interpretation and application of Part 12 of UNCLOS. Third, that the obligation to protect and preserve the marine environment under Article 192 of UNCLOS applies to the adverse impacts of climate change, and that the UNFCCC and the Paris Agreement are relevant to the measures to be taken to give effect to that obligation. Fourth, that the obligation to prevent, reduce and control pollution of the marine environment under Article 194(1) of UNCLOS imposes a due diligence obligation of conduct requiring best efforts, the content of which is variable and context-specific and may evolve over time. And fifth, ITLOS held that given the diffuse and cumulative causes and global effects of climate change, it would be difficult to specify how greenhouse gas emissions from activities under the jurisdiction and control of one state cause damage to other states. Australia makes 2 final points with respect to UNCLOS. With respect to Article 194(1), Australia contends that the UNFCCC and the Paris Agreement are the standards that the international community has agreed to prevent, reduce and control damage to the environment from greenhouse gas emissions and keep a 1.5 degrees future within reach. In respect of Article 194 sub 2, the same points that Australia made in relation to the unique nature of the harm caused by greenhouse gas emissions, which I've just addressed in the context of the inapplicability of the principle of prevention to such emissions, also apply in relation to Article 194(2). If accepted, those points have the consequence that the effects of greenhouse gas emissions are not within the scope of Article 194 sub 2 of UNCLOS. Thank you for your attention, Mr. President. I ask you to invite Dr. Parlett to conclude Australia's submissions.
I thank Mr. Donahue. I now give the floor to Ms. Kate Parlett. Madam.
B asks the court to consider the legal consequences in relation to a hypothetical situation in which a state has caused significant harm to the climate system. This invites consideration of 2 questions. Has an internationally wrongful act been committed? And if so, what are the legal consequences of that wrongful act? These questions refer to issues that are governed by customary international law as reflected in the International Law Commission's Articles on State Responsibility. However, as numerous participants have recognised, whether a breach of international law has occurred and its legal consequences are both context-specific questions. They are not amenable to resolution in the abstract. The answers will necessarily depend on the particular obligation that a state is alleged to have breached and the particular factual circumstances.
Australia therefore submits that the United Nations General Assembly and states would be best assisted by an opinion in which the court identifies the issues that would need to be considered and assessed in order to determine, in a specific context, whether a breach has occurred, and if so, its legal consequences. Such clarification would provide valuable guidance to participants, given the divergent views that have been expressed in these proceedings. A large number of participants have recognised that causation poses particular challenges in relation to climate change. As the court noted, in certain activities, issues of causation must be addressed as and when they arise in light of the facts of the case at hand and the evidence presented. Some participants have, however, asked the court to make generalised findings as to how difficulties relating to causation could be avoided. Australia submits that these general propositions should not be adopted by the court in its opinion. I will mention 4 by way of example. The first proposition is that a state can obtain reparation on the basis that injury has been caused to the climate system generally. However, for an obligation to make reparation to arise under customary international law, there must be a causal nexus between the wrongful act and an injury suffered by the claimant state specifically. In the absence of that causal nexus to an injury to a claimant state, there can be no basis for reparation. The second proposition is that the test for factual causation of injury in the context of reparation should be something lower than a but-for test. There is no sound basis for the application of a lower threshold in relation to all breaches of obligations relating to climate change. The court has applied the but-for test in relation to due diligence obligations of prevention. The authorities that are said to support a lower threshold, in fact, address different issues. They relate to causation in the different context of breach. They relate to legal causation, that is, remoteness and proximity, rather than factual causation, or they relate to proof of the extent of the injury, rather than proof of causation of injury. The third proposition is that there should be a presumption of causation in relation to climate change. However, in this context, there is no basis for reversing the general rule that a state seeking reparation must prove causation of injury. The onus of proof was reversed in the armed activities case because the respondent state was the occupying power of the relevant territory, and therefore it was in a better position to establish the relevant facts. The court emphasised the limited nature of that reversal, affirming that for damage alleged to have occurred outside the occupied territory, the burden of proof remained with the applicant state. The circumstances in which the onus was reversed in that case are not analogous. Fourth, as regards the potential application of Article 47 of the Articles on State Responsibility, that article does not apply to the conduct of states that contribute to climate change, such that the responsibility of an individual state could be invoked in relation to the wrongful conduct of states as a whole. The conduct of each state would be a separate internationally wrongful act, and based on current scientific understanding, those separate acts contribute to the same indivisible injury. Whether and how any responsibility to make reparation for that injury is to be apportioned is not addressed in the Articles on State Responsibility. And in these proceedings, the court does not have before it sufficient material to determine the existence, scope, and content of any rule of customary international law or general principle of law that governs such a situation. Of course, this is not to suggest that the rules reflected in the Articles on State Responsibility have limited utility in relation to climate change. Rather, it is to acknowledge that the challenges raised by causation are complex and cannot be resolved in the abstract and for all possible cases in these advisory proceedings. To conclude, Australia reiterates its commitment to addressing the significant threat posed by climate change at home and globally, and urges all states to accelerate global climate action to keep a 1.5 degrees of warming within reach. The Court has an important contribution to make in clarifying the obligations of all states to address climate change. Mr. President, Madam Vice President, members of the Court, I thank you for your kind attention.
I thank the representative of Australia for their presentation. Before I invite the next delegation to take the floor, the Court will observe a break of 15 minutes. The hearing is suspended.
That's our cue for very quick comments. So we just heard arguments by Antigua, Saudi Arabia, and Australia. Quite opposite views on many topics, especially, once again, the applicability of which regimes. Specifically, Antigua and Barbuda made a very compelling argument about the indivisibility between the climate and the human rights regime. So saying that compliance with the Paris Agreement is not enough for states to comply with other relevant obligations, including the context of human rights. And another point that Antigua focused on is the key role of science. I think they were the first ones, at least today, to address the question of the carbon budget, to assess states' obligations and level of action. And of course, to understand the carbon budget, science has a key role in understanding what's the fair share of each state in terms of emission reduction and relevant action. Another point that they did make, which was quite strong, was around the duty of reparation, saying that indeed, if breach of obligation occurs and harm is done, then that triggers the responsibility of state and thus duty of reparation from those states that are held responsible. And then we have, on the very end of the spectrum, Saudi Arabia, of course, that strongly stated that the climate change regime, specifically Paris Agreement, Kyoto, and the UNFCCC, do constitute a specialized regime, thus is the only one that should be applied in the context of climate change, and even asked the court to have a cautious approach as they answer the two questions. I found quite interesting that they did spend quite some time about the chapeau in the resolution of the GA that mandated the advisory opinion. The chapeau does in fact mention various treaties and legal instruments, including the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, thus human rights law. And Saudi Arabia was really adamant about the non-applicability of the chapeau, saying that that should not influence the court's decision on which body of law to focus on. And they also did mention the right to healthy environment, saying that this hasn't entered international law and thus should not be addressed by the court. Australia, they did make a point quite interesting about the harmonious interpretation of international law, so they definitely do not exclude other regimes, but they did stress the centrality of Paris, UNFCCC, and they spent quite some time on the UN Convention on the Law of the Sea. So that suggests that their approach is to have these sources of laws, the main one, and then see how other bodies can inform them. And they did spend quite some time in saying that answering the questions about the, especially the second question of whether if harms occur, reparation is due and what the consequences are. They mentioned the fact that these are heavily context-specific, and thus made the case that the court cannot really answer these questions because the question of harms, breach of obligation, and especially causation between the wrongful act and the harm suffered are definitely context-specific, and so imply that the courts could not reply in holistically to this question. I will stop there so that we can all enjoy a well-deserved break. I acknowledge that there are not many people left in the room, but there are some following us online. So Many thanks for those of you that are with us remotely. We will stop for around 15 minutes. We will resume at 4:45, and we will hear the arguments by Bahamas, Bangladesh, and Barbados, and then we will wrap up at around 6 p.m. Thanks again for being here. Sorry, for that notice.
exclusive economic zone is approximately the size of France. 80% of our land lies less than 1.5 meters above sea level, 80%. A sea level that is rising at an alarming rate, 0.5 meters above sea level, 80%. A sea level that is rising at an alarming rate, forcing us to recalibrate and adapt. Hurricanes and storm surges rip through our communities, bringing death and destruction. Rising sea levels and warming oceans decimate our coastal ecosystems, such as mangroves and seagrass, which used to provide a natural climate defense for our islands. Allow me to give you a few examples of how climate change affects the Bahamas. First, climate change has significantly altered weather in our region, making hurricanes more frequent and destructive. As a small island state in the Atlantic hurricane basin, we are particularly vulnerable. In 2021, the Climate Risk Index ranked the Bahamas third in the world for the most affected by weather-related events. All of our islands and all of my people are at risk. Still fresh in our memory is Hurricane Dorian, which devastated the Bahamas in 2019. More than 200 people died, nearly 10,000 people were displaced, and over 9,000 homes were destroyed. One of our more populated islands, both Abaco and Grand Bahama, were particularly hard hit. 75% of the dwellings in Abaco alone were damaged, and nearly 1/3 were completely destroyed. You could easily mistake this photograph for a pile of rubbish. However, what you are looking at are lost homes and lost livelihoods. A 20-foot storm surge rushed through the streets of these islands, contributing to approximately $3 billion in economic damage. That's about 25% of our annual GDP in just 2 days. The results of such a storm are real. They include displaced people, learning loss, livelihoods lost, and missing loved ones. All because some countries have ignored the warning signs of the climate crisis. Secondly, the Bahamas is a big ocean state who relies heavily on the resources of the sea, which have been under acute threat from climate change. The blue economy alone accounts for 40% of our economy. Oceans are absorbing a large amount of greenhouse gas emissions from the atmosphere, making them warmer and more acidic. This leads to the destruction of critical ecosystems, including our coral reefs, our mangrove forests, our seagrass, and our fish stock. That in turn affects our people's livelihoods, it reduces our biodiversity, and has ripple effects through the ecosystems which lose their protective properties. I ask you, who is going to retrain our fishermen when the fish are gone? And what is going to replace our tourism industry when the reefs and the beaches are gone? The Bahamas seagrass and mangroves are critical carbon sinks, mitigating the impacts of a warming planet. The Bahamas has 40% of the world's seagrasses. This vital climate mitigating asset are being destroyed at an alarming rate. Seagrass in the Bahamas has declined 1 to 2% each and every year, and extreme weather events have destroyed over 90% of viable mangroves in the Bahamas, all because industrial countries have ignored their obligations. We are currently witnessing the largest ever recorded mass coral bleaching event. The Bahamas is home to 5% of the world's coral reefs and the world's third longest barrier reef. Third, sea levels are rising and they will continue to rise, presenting an unprecedented challenge to the very survival of our nation. We are experiencing the effects due to decades of neglect by industrial countries. But long before our territory is submerged, we will feel the impact. We will feel coastal erosion. We will feel the flooding impact, salinization of our freshwater resources, and displacement of our vulnerable communities. By 2050, the Bahamas is projected to lose nearly 60% of its shoreline, the largest loss of land projected in the entire Caribbean region. By 2100, we will lose all of our sandy beaches in the Bahamas, all because warning signs have been ignored for generations. Excellencies, we experienced the threat of storm surges coupled with the rise in sea level, resulting in catastrophic flooding. The slides above show a grave impact of flooding that would occur caused by a storm surge with 1 meter, just 1 meter of sea level rise because of a hurricane impact. In a Category 3 storm, which is the middle slide, more than 50% of the island will be flooded. This is the capital of Nassau, where 2/3 of our population live. A Category 5 hurricane, which is the one on the far right, will result in nearly the entire island of Nassau being underwater. This is the reality in which we live. This is why we need action, and we need it now. The Bahamas is at risk of being uninhabitable due to the severe impacts caused by the historical and present neglect of regulatory enforcement. Mr. President, honorable members of the court, the world knows exactly what needs to be done, and the industrial countries have neglected it for decades in the interest of profits. It is time for these polluters to pay. The IPCC has been telling us for years that the only way to stop a warming planet is to make deep, rapid, and sustained cuts in the global greenhouse gas emissions. The world needs to reach net zero emissions by 2050, which requires a cut in the GHG emissions by at least 43% in the next 5 years. Industrial states need to take urgent action now and provide reparations for their decades of neglect. International law imposes robust individual obligations on states to mitigate their greenhouse gas emissions. Climate change is not some unstoppable force that individual states have no control upon. We must cut through the noise and accept that those whose activities have led to the current state of global affairs must offer a response that is commensurate with the destruction that has been caused. There is no parity, there's no fairness, there's no equity if those responsible continue to pass the buck. We insist on liability and we demand reparations. As I conclude, allow me to introduce two important principles. The principle of common but differentiated responsibilities recognizes the differing responsibilities of states to address climate change. And although we endorse this principle, it is not a get-out-of-jail card. Major emitters who self-identify as developing states cannot continue their current trajectory of greenhouse gas emissions. Each state is required to do everything possible to stabilize our climate system. All major emitters must effect deep, rapid, and sustained reduction of their greenhouse gas emissions. Otherwise, my people's suffering is only going to continue to increase. Equitable climate action must account for the disparity of impact on small island and low-lying states such as the Bahamas. Our climate systems do not recognize man-made boundaries, only the destruction. In the Bahamas, we see it in the mental health of our citizens. We see it in the repairing of roads, utilities, vital infrastructure. We see it in the lost workdays of our people. We see it in the learning loss of our children when they can't go to school. We see it as a revolving door of preparation, impact, and recovery. And then we reset that cycle. We prepare again, we have an impact, and then we recover again. And despite the hijacking that we witnessed at COP29, climate treaties such as the Paris Agreement make clear that developed states have obligations to provide financial and technical assistance to vulnerable states such as the Bahamas. I make one observation on the principle of sustainable development, which the court has endorsed as early as 1997 in Gabachukovo-Nadamurash judgment. I have been struck by the statements of states which invoke the so-called right to development as a justification to pursue unconstrained energy policies. The Bahamas also invokes the right to development. However, our development is and has been hindered by states who refuse to act against climate change. International law does not stand for that. One person's development cannot be another person's destruction. Instead, international law aims at the full realization of human rights for all people, and that includes my people in the Bahamas. Excellencies, I call on you not only to reaffirm the principles set out in the International Tribunal of Law of the Sea advisory opinion, but to go further. We must extend these principles to enable real, enforceable action and reparations, not just a continuation of false promises. The devastation is undeniable. If we continue on our current path, my country will cease to exist. And then, Your Excellencies, I ask the question, who then will take my people when their country does not exist anymore? We are not just speaking about numbers or projections. We are speaking about lives, cultures, and histories at risk of being erased completely. Let us act bold, and let us act decisively. Let us act for my people in the Commonwealth of the Bahamas, and frankly, let us act for all people around the globe. I want to thank you, Mr. President and honorable members of the court, for this esteemed privilege of appearing before you today on this very important issue. And I now ask the court for you kindly to invite Dr. Conway Blake to address you. Thank you very much.
I thank Mr. Binda, and I'll give the floor to Mr. Conway Blake.
Mr. President, honorable members of the court, it's a privilege to be before you on behalf of the Commonwealth of the Bahamas. The Bahamas has submitted 2 rounds of written submissions, and I refer you to those for a full account of our pleadings. Today, in the interest of time, I will focus on one issue: the binding nature of states' individual obligations to mitigate climate change. You have heard already, and will hear time and again, that these obligations are limited, that they do not have teeth, that they are impossible to establish as a matter of law, and that they reflect political aspiration rather than firm commitment. That is, with respect, wrong. Yes, climate change raises difficult legal and evidentiary issues. And yes, it may well be impossible at this stage to prevent fully the environmental harm from greenhouse gas emissions that are already accumulating in the atmosphere. As the agent for the Bahamas has already explained, we are witnesses to growing catastrophic harm every day. But international law does not allow states to avoid responsibility for their actions just because legal compliance is difficult. It requires the opposite. It requires that states do their utmost to minimize future harm, to adapt to harm that we know is coming, and to cooperate in pursuit of those aims. In the time available to me, I will briefly address states' individual obligations to effect deep, rapid, and sustained reduction of greenhouse gas emissions, both under customary international law and under the climate treaties. I first turn to customary international law. The applicable rule of law here is straightforward. As the court wrote in 1949 in the Corfu Channel case, it is every state's obligation not to allow knowingly its territory to be used for acts contrary to the rights of other states. This remains the law today. In international environmental law, this principle has evolved to require states to prevent activities in their territory that cause significant damage to the environment of other states. Historically, this duty was most visible in the context of harm that can be traced back to one, often neighboring state, like pollution that travels down a river or fumes from a factory that float across a national border. But greenhouse gas emissions, which the climate scientists tell us are the key drivers of climate change, fall squarely within the scope of that duty too. Greenhouse gas emissions are obviously not wastewater or smoke, but they behave like them, in that their release by one state worsens the environmental and human conditions in another state. And the damage, as explained by the agent for the Bahamas, is not simply significant. For states like the Bahamas, it is existential. You will hear others say that the prevention obligation does not apply to greenhouse gas emissions. But there is no principal reason for such limitation. As the court noted in Pulp Mills, the prevention obligation has its origins in the due diligence that is required of a state in its territory. The obligation applies generally and is not limited to specific activities or to the activities of neighboring states. And rightly so. Our understanding of environmental harm and sources of pollution evolves as society evolves. And the science today is clear. The factual link between greenhouse gas emissions and serious harm to the environment is well established. Thus, when a state emits excessive greenhouse gas emissions, it is damaging the environment of other states. That is sufficient to trigger an obligation to prevent such harm. Now, it may be difficult to link a specific portion of greenhouse gas to specific harm. There is no question that that presents a challenge for courts, particularly when addressing consequential issues such as reparations. But those evidentiary issues do not negate the existence of the obligation in the first place, and neither do they negate a finding of breach when a state fails to fulfill its due diligence obligations. Evidentiary difficulties also do not negate state responsibility or the duty to provide reparations. On this important issue, I refer the court to the Bahamas' written statements. Coming back to the prevention obligation under customary international law, the Bahamas submits that it has three essential characteristics. First, it requires states to act. The Bahamas accepts that the obligation does not require states to succeed in eliminating all harm, which may not be possible, but it does require states to act with due diligence, which in turn calls for ambitious action informed by the best available science. In the context of harm caused by greenhouse gas emissions, the IPCC has made it clear what needs to be done. States need to reach net zero emissions by the middle of the century, and to do so, they need to effect deep, rapid, and sustained reductions in greenhouse gas emissions starting now. Science must inform states' actions and policies in this regard. Second, the prevention obligation is onerous. It requires each state to use all means at its disposal to prevent transboundary harm from occurring. As the court explained in pulp mills, the measures can and should include adopting and enforcing legislation, regulating the conduct of private actors, and promoting transparency and broad public participation in environmental matters. What is key is that the state's action is ambitious and effective to have a real chance of preventing harm to the environment. Third, the required standard of care reflects the principle of proportionality. As such, each state's mitigation action should be broadly proportionate to its share of global greenhouse gas emissions. When over 60% of emissions come from only 5 states, their mitigation obligations are particularly onerous. Of course, that does not release other states from their own obligations, but the scale of the required effort pales in comparison. In addition, as the agent for the Bahamas has already discussed, the proportional allocation of mitigation duties must reflect the principle of common but differentiated responsibility, which is well recognized in international law. But CBDR does not eclipse proportionality rule itself. It rather informs our assessment of what legal burden a state can reasonably bear given its developmental capacity. That is all I wish to say today on the prevention obligation. I now want to turn briefly to the role of the climate treaties. They also impose individual obligations on states to mitigate. And unsurprisingly, such obligations are consistent with the state's obligations under customary international law. I will touch upon 2 obligations under the Paris Agreement. First, Article 4.2 of the Paris Agreement requires states to prepare, communicate, and maintain successive nationally determined contributions, or NDCs. These NDCs are not an aspirational wish list, or a purely discretionary decision, or an unguided exercise. Their setting is a matter of concrete binding obligations. Let us go back to first principle. Treaty obligations must be interpreted in light of the treaty's object and purpose. In the Paris Agreement, that is expressly stated in Article 2A. That is, to limit the increase in global average temperatures to well below 2 degrees above pre-industrial levels, and to pursue efforts to limit the temperature increase to 1.5 degrees. The Paris Agreement, like all other treaties, must also be performed in good faith. So while states are not obliged to achieve the temperature goal, they are required to set their NDCs in a way that makes it possible to achieve the aim. To that end, NDCs must reflect a state's highest possible ambition and represent a progression over time, and be informed by the decisions of the Conference of Parties and the outcomes of the global stocktake. Just a brief note here on the global stocktake, because the Paris Agreement expressly requires states to take it into account in their NDCs. The 2023 stocktake makes clear that states are not on track to achieve the temperature goal. States must therefore urgently take steps to set and meet NDCs that can in fact result in deep, rapid, and sustained reduction in global emissions in line with the 1.5 degree goal. That is what good faith requires. States' obligations under the Paris Agreement do not, however, end there. Article 4.2 also requires that states pursue domestic mitigation measures with a view to meeting their NDCs. This is not an obligation to actually meet the NDCs in all circumstances, but it requires that states act with diligence and pursue domestic policies which are reasonably aligned with their NDCs. One critical tool in the state's arsenal is the regulation of private actors, who generate a considerable portion of greenhouse gas emissions. And I refer the court to the Bahamas' written submissions, which discusses this obligation in more detail. In sum, states States must diligently pursue mitigation measures in line with their NDCs, which in turn must reflect states' progress or indeed their lack of progress towards the temperature goal. There is no other way of interpreting the Paris Agreement without doing grave violence to the fundamental principles of treaty interpretation or international law. At this juncture, it is worth noting that other rules of international law also give rise to mitigation obligations. These include the law of the sea and human rights, both of which enshrine binding norms on the protection of the environment. Earlier this year, ITLOS affirmed states' obligations to prevent and reduce marine pollution in the form of greenhouse gas emissions. In the human rights sphere, there is no shortage of judicial decisions affirming states' obligations under international law. I commend those decisions to the court and refer the court also to the Bahamas' written submissions on these matters. Mr. President, Excellencies, before I conclude, there is one final point I will mention briefly, and that is the interrelation of these various bodies of law applicable to climate change. It should be clear by now that they do not stand in opposition to each other. They are complementary and they reinforce each other. The idea, for instance, that the climate treaties alone are exhaustive of states' climate obligations has no support in the text of those treaties, in the history of their negotiations, or in their very purpose. The climate treaties refer to both human rights and the prevention obligation. They did not erase existing public international law, and those who claim otherwise provide no credible support for their proposition. The court should resist such harmful attempts to dilute and distort international law. Mr. President, honorable members of the court, you have the heavy burden of carrying out the court's mission of upholding international law. That mission is urgent and necessary as we all face the existential threat of climate change. On behalf of the Bahamas and the present and future generations of people who share this planet, I implore you to be bold as you pen and deliver your opinion. It has been an honor to appear before you, and I thank you for your kind attention.
I thank the representative of the Bahamas for their presentation. I now invite the next participating delegation, Bangladesh, to address the court, and I call upon His Excellency, Mr. Tariq Muhammad, to take the floor.
Mr. President, honorable members of the court, Assalamu alaikum, and good afternoon. It is an honor for me to appear before you today as the agent of the People's Republic of Bangladesh. I start by expressing our solidarity with other specially affected states, including small island developing states, as our fates are linked in the face of increasingly devastating impacts of climate change. For Bangladesh, the consequences of climate change are more than existential threat. They are our lived reality. We have been ranked the 7th most climate-affected country based on number of fatalities, climate events, and economic losses. Bangladesh's unique geography and low-lying delta topography have shaped its cities and towns and influenced its culture for nearly 4,000 years. But today, they leave us especially vulnerable to climate hazards. As you can see on this slide, Bangladesh is situated between the Himalayas to the north and the Bay of Bengal to the south. More than half of our 170 million residents live in the Ganges Delta, the world's largest river delta, which lies no more than 5 meters above sea level at its highest points. And Around 29% of the population lives in coastal areas with an average elevation of less than 1.5 meters. As a result, as depicted in this map, Bangladesh and its people face unprecedented catastrophe. Almost every part of my country is vulnerable to climate change impacts, including increasing salinity due to sea level rise, floods, cyclone and storm surges, severe weather, and drought. The human impact of the climate crisis in Bangladesh is devastating. People are dying as a direct result of climate change impact, such as severe storms and floods, and because these impacts increase the prevalence of diseases and other health issues. Millions of people have already suffered the loss of their homes, businesses, schools, and in some cases, their entire communities. Millions more are at risk. These impacts are driving an unprecedented displacement crisis in Bangladesh. By 2050, the number of internal climate migrants could reach almost 20 million if temperatures continue to rise. Around 2,000 people are moving to Dhaka, the capital of Bangladesh, every day, which, as you can see from the slide, is also susceptible to severe flooding. The financial impact of climate change reflects the scale of the human tragedy. The annual cost of climate-related disasters in Bangladesh is $3 billion a year. On top of that, it is estimated that investments of more than 400 billion are needed to meet Bangladesh's mitigation goals and adaptation needs. The adaptation finance gap is, quote, very large, unquote, according to the Adaptation Gap Report of 2024. The reality is that my beautiful country and its people are victims of a grave injustice and fundamental inequity. Our contributions to historic global emissions are negligible, barely 0.5%. Yet, we suffer the worst impacts. We, therefore, require climate justice now. We have been resilient in the face of this devastation, but we cannot address these issues alone. Climate-vulnerable states require a fundamental shift in the conduct of high-emitter states who are not doing enough to address climate change or its impacts. Recent reports from the World Meteorological Organization indicate that global average temperature exceeded 1.5 degrees Celsius for much of 2024. In the face of repeated disasters, it has become impossible to cope without compromising basic human rights and meeting the SDG obligations. We have witnessed the frustration, the lack of progress in the recently held COP29. The new collective quantified goal of $300 billion a year in climate finance falls woefully short of the amount needed. The countries which are victims of climate change manifested their frustration by staging a walkout. Even if NDCs are implemented, global temperature is set to rise to 2.8 degrees Celsius by 2100, which is a death warrant for the Mother Earth. The court has an essential role in redressing this injustice and clarifying the obligations of all states, especially the major polluters, in the face of this global crisis. Bangladesh has confidence in the court delivering a strong advisory opinion commensurate with the immense scale and gravity of the climate crisis. It cannot be the case that international law has nothing to say in the face of this existential threat to specifically affected states such as Bangladesh and to the whole of humanity. I turn now to Bangladesh's distinguished counsel, Professor Payam Akhavan and Ms. Catherine Merfar, who will address mitigation and adaptation respectively. I thank you all.
I thank His Excellency Mr. Tariq Muhammad. I now give the floor to Professor Payam Akhavan. You have the floor, sir.
Mr. President, distinguished members of the court, I'm honored to appear in this historic proceeding on behalf of the People's Republic of Bangladesh. I will be addressing the harmonization of the multiple regimes of international law referred to in the first question before the court. These different branches of international law are all from the same tree, and they all lead to a single overriding obligation, namely that all states must take the necessary measures to deeply and rapidly mitigate anthropogenic greenhouse gas emissions to avoid breaching the 1.5 degrees Celsius threshold, with the greatest burden falling on the developed and high-emitting states. As recognized in the reports of the IPCC and the Paris Agreement, holding the increase in global temperature to 1.5 degrees Celsius would significantly reduce the risks and impacts of climate change. This pivotal obligation arises from distinct but interrelated and mutually reinforcing legal regimes, including principles of customary international law on transboundary harm to the environment, the UN climate change regime, comprised primarily of the UNFCCC and Paris Agreement, and fundamental norms of international human rights law, including the right to development. And all are to be applied in conjunction with the principle of common but differentiated responsibilities. I will speak to each in turn. First, as the court recognized in pulp mills, under customary international law, each state is under a core obligation to use all means at its disposal to prevent activities taking place in its territory that cause significant damage to the environment of another state. There is no doubt that greenhouse gas emissions cause significant, indeed catastrophic, transboundary harm. Their long-term and global impact in no way diminishes application of this fundamental principle. Moreover, as confirmed in the unanimous ITLOS advisory opinion on climate change, a stringent standard of due diligence applies in preventing harm to the marine environment. The core obligations under UNCLOS Part 12 reflect customary international law. There is no reason why a less exacting standard should apply to the environment as a whole. Second, while the UN climate change regime is critical to mitigation, it is not the last word on states' obligations. The obligations under those treaties are largely procedural. They simply require states to formulate and communicate nationally determined contributions reflecting their highest possible ambition, and to ensure that successive contributions represent a progression of efforts over time. Some have argued in these proceedings that this specialized regime is somehow self-contained or even lex specialis, with the consequence that international law cannot impose obligations that go beyond the Paris Agreement. That position is manifestly inconsistent with the strong presumption against normative conflict and fragmentation. As the court noted in the right of passage over Indian territory case, treaties should be interpreted as producing and as intended to produce effects in accordance with existing law and not in violation of it. It cannot be that the Paris Agreement is intended to violate pre-existing obligations to protect the environment. It is notable that in 1993, the court had created a chamber for environmental matters. It was discontinued in 2006 because, as President Higgins explained at the time, states understandably saw environmental law as part of international law as a whole. It cannot be that the intention of the Paris Agreement is to protect the planetary climate system by excluding international law as a whole, not least when our common survival is at stake. In the words of the ILC report on fragmentation, without the principle of systemic integration, it would be impossible to give expression to and keep alive any sense of the common good of humankind. Bangladesh notes further that for lex specialis to apply, there must be some actual inconsistency between norms. But there is no such conflict between the Paris Agreement and general international law. Simply put, the lex specialis argument is missing the lex. It was squarely rejected by ITLOS, and it should similarly be rejected by this court. Mr. President, invoking the Paris Agreement to avoid pre-existing obligations is particularly troubling because the Earth has already reached a year-long temperature exceeding 1.5 degrees Celsius. There is obviously a substantial emissions gap. It cannot be that grossly inadequate NDCs somehow satisfy the obligation to protect the environment. It is high time for the faltering COP process to be reinvigorated by a robust opinion from this court. The time for empty promises has passed. I now turn to the third point, namely that climate change poses an immediate, if not the greatest threat to human rights. In its resolution 56-8 of 10 July 2024, the UN Human Rights Council expressed extreme concern that climate change poses an existential threat to some countries and has already had an adverse impact on the full and effective enjoyment of human rights. This places climate-vulnerable states such as Bangladesh in an untenable position where human rights on their territory are adversely impacted by the conduct of other states. This implicates the interstate dimension of human rights obligations, including Article 2.1 of the Covenant on Economic, Social and Cultural Rights, requiring states parties to take steps individually and through international assistance and cooperation, especially economic and technical, to achieve progressively the full realization of rights. It is reinforced by the UN Declaration on the Right to Development, recognizing the duty of cooperation in ensuring development and eliminating obstacles to development. At a minimum, states must not impede another state's ability to protect and ensure the rights of its population. The fourth point is that these norms must be applied in conjunction with the principle of common but differentiated responsibilities. This requires developed states to mitigate emissions consistent with their greater financial and technical capabilities, even if all states must make mitigation efforts. This is a fundamental aspect of the equity that international law requires. I return to where I started. Each of these legal regimes leads to one overarching obligation to mitigate emissions to avoid breaching the 1.5 degrees Celsius threshold. This is the key obligation, as it is the only way to prevent the catastrophic harms predicted by the IPCC in a 2-degree or 3-degree Celsius scenario. But it is not enough. We are already at the 1.5 degree Celsius threshold. Even if all states immediately reduced emissions to meet their obligations, it would not undo the impacts already being suffered in Bangladesh, let alone stop future irreversible harms. This takes me to my fifth and final point. It is deeply unfair that countries like Bangladesh, that have contributed the least to global emissions, are paying the highest price, forced to make enormous investments to adapt to the catastrophes caused by high-emitting states. Mr. President, distinguished members of the Court, behind the abstract legal questions that are before you, beyond the walls of this great Hall of Justice, is a world of immense suffering. The momentous words that you weave in this historic opinion should guide states away from the precipice, and it should give hope to those who despair from this injustice. It calls to mind the words of the legendary Bengali poet Rabindranath Tagore, "I shall weave a chain of pearls with my tears of sorrow." This concludes my remarks. I thank you for your kind attention, and I ask that you please invite Ms. Amirfar to address you.
I thank Professor Akhavan. I now give the floor to Ms. Catherine Amirfar. Madam.
Mr. President, honorable members of the Court, it is a true privilege to appear before you on behalf of the People's Republic of Bangladesh. I will address the set of specific obligations in respect of climate adaptation in light of what has already been said about harmonization. I turn first to the relationship between mitigation and adaptation. Adaptation has received less attention from participating states and international organizations in their written submissions. But even as mitigation remains central to preventing harm, for climate-vulnerable states like Bangladesh, ensuring that the necessary steps are taken to adapt to current and unavoidable future climate impacts is equally important. As we begin these historic proceedings, we face a stark reality. Negative climate impacts are already devastating Bangladesh and climate-vulnerable states. The international consensus on the best available science demonstrates that, given where we stand today, even effective mitigation of GHG emissions is not enough to remedy these impacts or prevent further negative impacts, which the IPCC concludes will continue to worsen even under a 1.5 degrees Celsius scenario and reach catastrophic levels at a 2 degree or 3 degrees Celsius scenario. In addition, according to the IPCC, in many instances, the extent of the climate crisis means that, quote, limits to adaptation have been reached, so that even with adaptation measures in place, not all loss and damage will be prevented. Accordingly, the best available science tells us that climate adaptation measures are equally essential part of the response to existing and unavoidable future harms. As multiple states acknowledge, adaptation-related obligations are primary obligations. They are not alternatives to mitigation, but are required in parallel, and in some circumstances, the same measures may be required in relation to both. For example, measures supporting ecosystem resilience as a means of adaptation, such as restoring wetlands to provide a barrier to sea level rise, also create carbon sinks in support of states' mitigation obligations. ITLOS confirmed this point in the context of states' customary obligation to protect and preserve the marine environment. At the same time, adaptation measures are also secondary obligations that can arise when states violate their obligations to mitigate GHG emissions in line with the best available science.
Where unmitigated GHG emissions cause harm, for example, by increasing the frequency and strength of devastating weather events, then responsible states must assist injured states with the adaptation measures necessary to remedy that harm as a form of restitution or compensation. As such, states' adaptation-related obligations are preventive and responsive in nature and relevant to both questions A and B. Turning to my second point, the same legal framework underpins states' mitigation and adaptation obligations. This includes the core obligation under customary international environmental law to prevent and reduce significant transboundary harms related to GHG emissions, the duty of due diligence measured on an objective and stringent basis, the duty to cooperate to, quote, jointly manage the risks of damage to the environment, territorial sovereignty and self-determination, international human rights obligations, and express requirements in respect of adaptation under the UN climate change regime and UNCLOS. As in the mitigation context, adaptation obligations are informed by the best available science and subject to the principle of common but differentiated responsibilities. Accordingly, state-specific adaptation obligations will be based on their technical and financial capabilities and their historical contributions to climate change. At least 4 specific concrete obligations in respect of adaptation flow from this normative framework. First, developed states must take affirmative measures to ensure that the funds necessary to adapt to climate impacts are available and accessible. The IPCC has concluded that, quote, gaps exist between current levels of adaptation and levels needed to respond to impacts and reduce climate risks, end quote, and that at current rates of planning and implementation, these gaps will continue to grow. This is driven in part by the disparity between the costs of adaptation and currently available funds, particularly for developing states. At a minimum, then, existing financial commitments in support of climate vulnerable states must be met, but that is not enough. In line with the best available science and principle of CBDR, states must increase their financial contributions to levels necessary to meet global adaptation needs effectively. Some states argue that there is no enforceable obligation to increase financing, citing to the use of term goals in the UN climate change regime. But any argument that the UN climate change regime covers the field or otherwise displaces obligations under international law must be rejected for the reasons Professor Akhavan discussed. In addition, the undue emphasis placed on the term goals ignores the mandatory language used in other provisions of the UN climate change regime. Article 4.4 of the UNFCCC provides that developed states, quote, shall also assist, end quote, developing states in, quote, meeting costs of adaptation, end quote. The Paris Agreement is likewise not aspirational. Under Article 7.9, for example, all states, quote, shall, as appropriate, engage in adaptation planning processes and the implementation of, end quote, adaptation actions. Article 9.1 demands that developed states, quote, shall provide financial resources to assist developing country parties with respect to both mitigation and adaptation. And as confirmed by the ITLOS advisory opinion, Article 192 of UNCLOS, quote, requires states to implement measures to protect and preserve the marine environment that include resilience and adaptation actions as described in the climate change treaties. The tribunal specifically noted that, quote, measures of adaptation and resilience building frequently require significant resources, end quote, referring to Part 12 of UNCLOS, especially Articles 202 and 203, which require assistance to developing states. Second, Developed states must cooperate by contributing relevant scientific, technological, technical, socioeconomic, and legal information to developing and climate vulnerable states, as required under the Paris Agreement and UNCLOS. The dissemination of clean and green technologies to climate vulnerable states at affordable costs is also required. This was originally contemplated under Agenda 21, adopted during the UN Conference on Environment and Development over 30 years ago. It has since been incorporated into decisions of the parties to the UNFCCC, Article 10 of the Paris Agreement, and is required by Articles 202 and 203 of UNCLOS. Third, states must take steps to preserve and restore climate-resilient ecosystems such as wetlands like mangrove forests. States must also comply with stringent due diligence obligations such as environmental impact assessments of public and private activities within a state's jurisdiction or control that may cause significant harm through GHG emissions, including cumulative effects. This also encompasses continuously monitoring environmental impacts to protect and preserve such ecosystems. Finally, states must take positive steps to fund or otherwise contribute to capacity building measures in climate vulnerable states to protect and ensure fundamental human rights, given that mitigation alone is insufficient to undo existing and avoid all future adverse impacts. For example, the IPCC has stressed the need to, quote, increase adaptive capacities to minimize the negative impacts of climate-related displacement, end quote, which is relevant to the nearly 20 million people at risk of displacement in Bangladesh. This might include, for example, measures to accommodate displaced communities and to build resilient structures to prevent future losses. I close my remarks by stressing the urgent need for adaptation measures to address the catastrophic effects of climate change. As you heard from the agent, millions of people in Bangladesh have already been affected. Millions more are at imminent risk. The devastating consequences for global peace and stability and human dignity flowing from the displacement of hundreds of millions of climate change migrants and refugees worldwide by mid-century is staggering to contemplate. The court's clarification of what states must do now as a matter of legally binding obligations to avert such a terrible future comes at a critical juncture for our world. Thank you, Mr. President, honorable members of the court, for your kind attention and your patience. This concludes the submissions of Bangladesh.
I now invite the next participating delegation, Barbados, to make its oral statement before the court, and I call upon His Excellency Kerry Simons to take the floor.
Mr. President, Madam Vice President, honorable members of the court, I am Kerry Simons and I am Barbados' Minister of Foreign Affairs and Foreign Trade. Mr. President, Barbados has taken the unprecedented step of making 2 sets of extensive written submissions and appearing before you today for one simple reason. The climate crisis which lies at the heart of these proceedings is for us an imminent matter of life and death. It is not, Mr. President, a statistical matter. It is not a theoretical or speculative matter, but it is a matter of life and death, simply because of the fact that for people of small island developing states such as mine, there is nowhere to go when confronted with rising sea levels. There is no hinterland. There is no interior. There is no area of as yet unexplored territory. All that we have is 166 square miles of land for our 300,000 residents. Small islands like ours, Mr. President, are surrounded by coral reefs that play a key role in nurturing and protecting coastal communities and facilitating nearshore economic activities such as fishing and leisure. The sea is therefore not only the home to our biodiversity, but it is also the source of our nation's livelihood. Carbon emissions from human activity are causing ocean warming and acidification, which in turn places our coral reef and its entire ecosystem at extreme risk. As a consequence, everything, Mr. President, that we have painstakingly constructed as a nation and as a people is now placed at risk because of the climate crisis. The tourism sector, for example, which has buoyed our economic fortunes for the better part of a century, is now at risk. The fishing sector, which has been a sustainable source of protein for generations of Barbadians, thousands of Barbadians, Mr. President, is now at risk. The sugarcane industry, which we have grown for hundreds of years and from which we have distilled a world-famous rum, is also at risk. Mr. President and your honourable members, you have heard and will no doubt hear more about the record-breaking Hurricane Beryl, which passed through the Caribbean area earlier this year. Hurricane Beryl moved from being a simple tropical storm to being a Category 5 hurricane in approximately 24 hours. Hurricane Beryl struck Barbados and destroyed 90% of Barbados's fishing fleet, a fleet which had been hauled behind the protection of marinas and breakwaters which had existed for the past 35 years. 35 years. However, such was the unprecedented intensity of the waves Beryl sent our way that those near 40-year-old protections proved insufficient, and marinas that had hitherto provided sanctuary became scenes of mass destruction. Destruction which is now estimated to cost over 100 million United States dollars to replace. 100 million United States dollars, Mr. President, of unplanned expenditure accruing to a micro-state with a micro-economy with 1 day's notice. What you might not have heard about is another startling example of the effects of climate crisis in the Caribbean, and I refer specifically to periods of prolonged drought. The first 5 months of the year 2023, for example, saw levels of rainfall which were 53% below the preceding 30-year average, below the preceding 30 years average for Barbados during the first 5 months of those years. Storms like Beryl, periods of prolonged drought, slow onset phenomena such as sea level rise, and rising temperatures are the catastrophic new normal which has become our lived reality. Mr. President, the economic consequences are no less palpable than the environmental consequences to which I have just referred. Even as productive sectors are being affected, the ability of the state to provide support is undermined by rising cost of finance and increasingly the challenge of securing sustainable insurance. This challenge exists because insurance companies themselves are now becoming more risk-averse in the face of more frequent, more powerful, and more devastating storms. So that my country, therefore, like some regions in larger countries, is now in grave danger of becoming uninsurable. And it follows logically, Mr. President, that without the ability to access or sustain insurance premia, a country's economy will also then become uninvestable. Barbados contends, and science clearly demonstrates, that these are the consequences of this man-made climate crisis, a crisis towards which Barbados and small island developing states have contributed almost nothing, but which may take away everything that we have. Mr. President, honourable members of the court, Barbados is a firm believer in the international legal order, and that is why 44 years ago we accepted this court's compulsory jurisdiction. Today we appear for the first time before this court respectfully to request clear answers to clear questions posed unanimously by the UN General Assembly. The serene picture of Barbados, Mr. President, I leave with you with the words of one of the Caribbean's most famous poets, Barbadian Kamau Brathwaite, in his poem South. He says, bright waves splash from the rocks to refresh us, blue seashells shift in their wake, and there is the thatch of fishermen's houses, the path made of pebbles, and look, small urchins combing the beaches, looking up from their traps to salute us. Fishermen hawking the surf on this side of the reef, stand in their boat and hallow us. That serene picture stands to be obliterated if we do not cease the forms of global conduct which will leave our island uninsurable, uninvestable, and ultimately uninhabitable. Mr. President, I request to be followed sequentially by Ambassador Francois Jackman, Barbados's co-representative, Professor Robert Volterra, co-representative, and Mr. Gunjan Sharma, External Legal Counsel for Barbados.
I thank His Excellency Kerry Simmons. I now give the floor to His Excellency Francois Jackman. Sir, you have the floor.
Mr. President, honourable members of the Court, I wish to speak briefly about the international context surrounding the climate crisis and to highlight a key initiative taken by the Government of Barbados to address these challenges. You will be aware that many countries and advocates in the fight against the climate crisis were deeply disappointed by the recent outcomes of COP29 in Baku. A target of $300 billion per annum for climate finance was agreed, whereas it is generally accepted that $1.3 trillion per annum is in fact required. We agreed in the Paris COP21 almost a decade ago that as an international community, we would seek to limit global warming to 1.5 degrees centigrade above pre-industrial levels. Today, we are headed well past this point with continued growth in greenhouse gas emissions. Barbados, like many other countries, had put great faith in this negotiation process and in the undertakings of the states. To say that we Barbadians are disappointed is to measure the distance between what has over the years been promised against what has in fact been delivered. The massive gaps between promise and delivery are at the heart of the climate crisis for developing countries in general and for small island developing states like Barbados in particular. It is to address the climate financing crisis in particular that Barbados has piloted the Bridgetown Initiative. Monsieur le Président, Mesdames...
Mr. President, honourable members of the Court, the climate financing crisis is intimately linked to the chronic insufficiencies of the global financial system. That's a system which, in the view of the UN Secretary-General himself, is absolutely not up to the task. Let me quote him. Instead of having a safety net, developing countries are confronted by an obsolete system which is both dysfunctional and unfair, and which does not meet their needs. End of citation. So Barbados put in the heart of its diplomacy the Bridgetown Initiative. Now that aims at reforming from the bottom up the global financial system with specific regard to climate change. International financial institutions such as the World Bank and the IMF would thus be fully able to fulfill their function to support countries in the implementation of the Sustainable Development Goals as set out in UN Agenda 2030. These institutions, together with other institutions and financial instruments such as regional development banks, the private sector, including insurance companies, levies on a certain number of industrial and economic activities, and the philanthropic sector, will thus be able to fill this vast and perilous financial shortfall to which I referred. Mr. President, distinguished members of the Court, as a conclusion, I would like to repeat a conclusion which, in a principle, for my country is of signal importance. We're not here today looking for a handout. Rather, as we have stated in our written statement, we seek justice. Those states which are responsible for climate change have the obligation under international law, as will be explained in greater detail by my colleagues, to provide complete and effective reparation for this harm. A renewed and reformed financial system, as proposed by the Bridgetown Initiative et al., is one of the key elements of this justice.
I'll ask the court to call upon Professor Robert Volterra, co-representative of Barbados, to continue Barbados's submissions. I thank you.
Je remercie l'ambassadeur François Jacquemin and
thank you, Ambassador Jacquemin.
Mr. Robert Volterra.
Mr. President, Madam Vice President, judges, it is an honor to appear once again before this court. I make submissions today in my capacity as co-representative of Barbados. Barbados has submitted 2 written pleadings in these proceedings. They are 332 pages long. They contain over 1,000 citations. These include 84 scientific papers, 54 academic citations, and 505 legal authorities. Barbados reaffirms its written submissions, but of course it's not possible to summarize them today. Therefore, in its remaining time, Barbados will focus on 4 submissions. They concern 1, the applicable law; 2, the doctrine of strict liability; 3, causation and attribution; and 4, foreseeability.
We are abruptly stopping the oral hearing because unfortunately logistics here at the UN prevent us from watching it till the end. We have to vacate the room in 5 minutes. In any case, these hearings are recorded, so for those who would like to keep watching it, they can go on UN TV. It's hard to provide a wrap-up. I would just comment on this afternoon's hearings on the second part to say that we heard more aligned arguments, specifically about how interrelated different bodies of laws are, and that Paris Agreement, UNFCCC, should not qualify as lex specialis, and thus the only relevant body of law, but actually should be interpreted in line with other relevant obligations, including, of course, customary law, environmental law, and human rights law. I think both the 3 countries that spoke referred to common but differentiated responsibilities as one of the key principles that should also inform the level of action by states. But as Bahamas strongly pointed out, that shouldn't be an excuse by large emitters that do still qualify or self-qualify as developing countries as an excuse to continue high levels of emissions globally. Once again, it was reiterated the fact that once it is established that an internationally wrongful act has been committed and that harm has occurred, then there is responsibility that is triggered. Bangladesh specifically mentioned duties of reparations, for instance, in the form of finance for adaptation and addressing loss and damage that should go hand in hand with the mitigation obligations. And of course, together with technologies transfer. I think I will stop here. We heard, it's been a long day. We heard many points. I think that the different arguments that we heard represent well the spectrum of positions that we will be witnessing over the next couple of weeks. I would perhaps turn to Yves Lador, if you want to share some reactions. A lot has been said. It wouldn't be possible to summarize everything in a couple of minutes. But maybe since you are really grounded in Geneva, once again, if you want to provide some reflections on how, as a community based in Geneva, working on human rights, we can really take stock and build on this process, I think it would be very helpful.
Yeah, thank you very much, Francesca. And of course, I will not try to summarize what has been said. There's really too much. Just a few reactions. As you said, we really heard, in a way, two of the extremes arguments that will frame, I think, the whole 2 weeks of testimonies that will happen now. We heard on one side some very, very affected states or impacted states, and on the other side, we heard some states from the north or from oil producers. And even though you can have some nuances in the way they are presenting their arguments, some are bluntly clear, almost denying science, any role to science, or denying almost climate change. There is clearly here a gap, because what really struck me in what we heard today is that even though some countries from the north who are trying to present themselves as being rather progressive and open-minded and so on, once you really look at the legal argument at the end, basically they were pretty much aligned to the argument that was formulated by Saudi Arabia. And that was really very, very striking. Because even when they were saying, yes, of course, you can combine, basically Saudi Arabia said you cannot combine the different regimes. That's basically the heart of their argument. Those who are saying, yes, you can, at the end, they were basically going, well, but at the end it goes back to the UNFCCC, and which basically is just volunteer, and then we don't have any obligations. So there's a bit of a trick, and I'm afraid that we're going to hear more and more of these type of arguments in the coming days. What was really very interesting, of course, we heard a lot of very dramatic statements, and rightly so, unfortunately, because of what's happening on the ground, from a number of directly affected states, as I call them. But there was one thing which was really very interesting in the statement of Bahamas, because they did not just stick to this aspect of those who have and those who have not. They also called very clearly that all developing states who are still keeping high emissions must change their way. And there was a very strong statement that one person's development cannot be done at the stake of another person's destruction. And this is a very, very strong argument. Of course, very much a human rights argument. We've been formulating here for a long time. And it's quite interesting to hear this, because it does also say something about what happened at COP29, where we did have this kind of block discussions, but that does not reflect, and here that was very clear, does not reflect the variety of situation and positions that we have throughout the world. So I think here it was a very, very interesting and strong statement. I think also the argument that was done by Bangladesh at the end, this focus given to adaptation is very important, because adaptation has been mentioned by other states frequently, of course, and that's logical. But here there was a really very interesting legal argument about the obligation that relates to adaptation and how much adaptation. I think it was a very well-formulated argument on how adaptation is absolutely needed. And first is not an alternative to mitigation. And actually the three pillars of the UNFCCC, which is mitigation, adaptation, and loss and damage, have to go together. And there's scientific reasons for that. And that was very well explained in the final intervention of Bangladesh. So I hope that over the coming days we will continue to have these type of arguments, because we do see, because here it's an argument done in front of a court, that you must bring, hard facts, clear legal arguments, clear evidence. I hope this will help to develop and perhaps enrich the dialogue and the discussions we have, which sometimes, and I'll finish on that, what is happening in Geneva. We very often, and I've said more than once, that I don't think that the human rights system has still totally delivered what it should be delivering in the field of climate change. And very often we are, in a way, contaminated by the political discussions going within UNFCCC. And we hear this regularly. And what is interesting is that here we have sometimes more focused arguments, stronger argumentation, and stronger structure in what is being presented. And I hope that out of this, we will be able to take part of this in order to also bring it here in the discussions that we have in Geneva. And I think it's a need, and I think it's what we heard again and again is so relevant to the work that we're doing here in Geneva that I hope we will be able to do this connection. discussion. So I really encourage everybody to listen as much as possible to all of the arguments. I think it will be needed to enrich the discussion we have here. And I want to thank Bangladesh for still being with us this afternoon. We have contacts on a regular basis, but I would say that I'm really encouraged to continue the discussion and actually to push this discussion further with you and with the core group on the resolution on climate change, especially after what your country has presented here at the hearing. I think this is really a new ground to further discussions, and I hope we will be able to see this translated in the dialogue we'll have for the June session of next year. So yeah, we are going after this day, and of course after this time, we will be going back with a lot of things to do here for the work done in Geneva. Thank you very much.
Thank you, Yves. And building on what you just said about the importance of integrating different silos and forums, just wanted to recall once again the event that we're having on the 12th of December from 6:30 p.m. to 8 p.m. at the Geneva Academy at Villa-Moigné. And the idea is really to include many special rapporteurs that will be in Geneva for the annual meeting. We will have the special rapporteur on climate, the special rapporteur on extreme poverty, a member of the working group on business and human rights, the special rapporteur on development. We will also, and the special rapporteur on the environment. We will also hear from representatives of youth groups and states, including Luxembourg. We really hope to see many of you there. The link, the page has just been created on the Geneva Academy website, and Jen will, as usual, circulate further information. A huge thanks to all of you for sticking together and with us, including those following us online. It's been a very long day, a lot of food for thoughts. Thank you so much once again to the Geneva Environment Network for the support, Justice. The Geneva Academy is one of the co-organizers. We wouldn't have been able to pull out this event without a joint effort. Looking forward to continuing to engaging, and wishing you a very good evening for the time being. Thank you.